Glad I did that story. And you made it better. Don't you? I mean, I thought your comment was the best one because there really are a number of things going on there.
Right.
And if you write a story that says it's all one thing, that's probably not true. And it's certainly.
My stuff makes it a little bit more boring. There's so many things going on, and you can't just lock it in on one.
No, I don't. Right approach. I was almost surprised. You know, I actually had the fear last week that Friday afternoon when we got down here at Williamsburg, that's when they were going to hand out that order. And I thought, oh, this is a late Friday afternoon goddamn order that sort of ruined my weekend. So I guess I'm glad they did it. And I also
Won't wreck up your weekend.
yeah, so the timing is convenient. And I'm so surprised there were only 2 dissents.
What do you think of that?
You think it really wasn't? Just a well pagan environment. If they disagreed, why wouldn't they dissent?
I tend to not believe those people who tell me that people aren't gonna, you don't know what people are doing.
In other words, you think 7-2 was the split. In a case like
In all
this,
likelihood.
in a case like this, I can't think of a good reason otherwise. I mean, if Ruth Ginsburg were in the hospital or something like that, and there was a missing vote, I might think she was not available or something.
I think Kagan and Ryer both, if they think one side is loaded, they're not going to dissent because they're going to lose credibility.
So, in other words, you think they were willing to go along with the order?
Just because they thought the government's position was so much stronger than the other position. But for whatever reason, I don't know anything about it, but I know that the justice thinks one position is way stronger than the other. And she's going to be that's what's going to be as high. And she's going to lose credibility with the chief if she dissents in this case. If it's more evenly balanced, she's not going to lose any credibility. But if the chief sees this as like a landslide issue, and she's down there dissenting, he's going to go like, well, okay, she's just like the rest. That's why I feel. It's ridiculous. It's one of those cases that,
Do you think Tiger's extra injunction on Monday, I was wondering if that had any effect. I thought that was really a stupid move. The Ninth Circuit reins him in and says only in the Ninth Circuit, and he turns around and issues another nationwide injunction. That's really inviting
asking for it.
Inviting a reversal. Good luck.
They sent me an email asking me what I want.
You're going to be worried. No, it would have been recent. Maybe I met
Hey, how are you? Good.
Yeah. I guess that's also not shot. Yes, we do. You want to monitor. Money? You like expressed to me the service? And I was like, yeah, it's not like I took $5. I was like, it's just not No, that's
All right, we're going to get started now. Not exactly.
Pretty close.
Okay, we're going to get started. All right. Okay, well, welcome. My name is Neil Devins. I'm a law professor here. I'm director of the Institute of Bill of Rights Law, and on behalf of the law school and the Institute, welcome to the Supreme Court preview. We begin the preview with the Moot Court on one of this term's most discussed cases. The case is Bostic v. Clayton County, Georgia. At issue is whether Title VII prohibits discrimination on the basis of sexual orientation. There is language in Title VII that speaks to discrimination because of sex, and the question presented in the case is whether that includes sexual orientation discrimination. In June 2013, Gerald Bostic was fired from his job in Clayton County, Georgia. He was a welfare services coordinator. Clayton County claimed that he misappropriated, pardon me? Oh, I'm sorry. Clayton County claimed that he misappropriated funds. Bostic claimed that he was fired because of his sexual orientation. Bostic sued, and in May 2018, the 11th Circuit Court of Appeals ruled against Bostic, pointing to an earlier circuit precedent saying that sexual orientation was not included in Title VII. In July 2018, the 11th Circuit refused to reconsider the case en banc. Bostic then appealed to the U.S. Supreme Court. On April 22, 2019, the Supreme Court granted certiorari in Bostic and a second case raising identical issues, Altitude Express v. Zarda. Zarda was a Second Circuit case where in February 2018, the Second Circuit ruled en banc that Title VII did include discrimination on the basis of sexual orientation. Our advocates tonight are Adam Unikowski from the Jenner & Block law firm. Adam is representing the petitioner Bostic, and Irv Gorenstein from Georgetown Law Center, the Supreme Court Institute there, and Irv is representing Clayton County, Georgia. So with that bit of background, we're going to start our moot court.
Oh yay, oh yay, oh yay. The Supreme Court of the United States is now in session. The Honorable Chief Justice Joan Biskupic presiding. All those having cause to be before this honorable court, draw nigh and pay heed. God save the United States in this honorable court. Please be seated.
All right, we made it. We did it.
We will now hear arguments in the combined cases of Bostic versus Clayton County and Altitude Express versus Zarda. Mr. Unikowski, I understand you want to reserve 3 minutes of time for rebuttal? Okay.
Madam Chief Justice, and may it please the court. The employees in this case were fired because they're men who are attracted to men. If they were women who are attracted to men, they wouldn't have been fired. As such, this is a straightforward case of discrimination because of their sex in violation of Title VII. I think a straightforward hypothetical will explain why we really think this is a case of sex discrimination. Suppose you had an employee who worked in a different office from the employee's boss, but regularly emailed the boss and referred to the employee's husband. And say the employee's name was Chris, so you couldn't tell whether it was a man or woman. So one day the employee shows up at the main office and meets the boss. And the boss is shocked to learn that the employee's a man. And the boss says, look, if you were a woman as I had thought, you wouldn't be fired. But because I now see in front of me that you're a man, you're fired. So it's hard to see how that's anything other than discrimination because of sex when the person's literally being told that they're fired because they're a man as opposed to being a woman.
Counsel, can I ask you, though, you rely a lot on the text of the statute, but the text actually says because of the individual sex, doesn't it? And they're talking about the individual, the employee's sex. And doesn't that suggest that it should be a test that can be discerned by looking at the individual alone without this kind of associational aspect? That seems to go beyond the text of the statute.
I don't think it does, Your Honor. I think that what the text of the statute says is you have to determine whether or not, if you hold the facts the same but change it from a man to a woman or from a woman to a man, the employment decision would have been the same. And the hypothetical I just gave, it's clear that the person discriminated because he, in that particular scenario, it's a man versus a woman. Now, it's true that only a subclass of employees are discriminated in the sense, not all employees, but only men with husbands. But still, in the Phillips case, this court held that that form of sex plus discrimination was recognized under Title VII. So in that case, women with children were discriminated against, and that was held to be discrimination because of sex. even though only a subclass of people, people with children, encounter discrimination.
Can I ask you how that applies in the context of grooming standards? So what if I keep your hypothetical exactly the same and say, if you were a woman with long hair, you wouldn't be fired, but because you are a man with long hair, I'm firing you. I mean, under your sort of straightforward textual, that's also sex discrimination, right?
So I think that is sex discrimination, but it might not violate Title VII for a couple of reasons. First of all, I don't think that's really necessarily an adverse employment action. Maybe not be discrimination in the terms and conditions of employment.
Well, if I fire you for having long hair, that's certainly discrimination in the terms of conditions of
Well,
employment.
in that case, you'd be fired for violating the rule, and if the rule itself is not discriminatory, then I think that there's a neutral reason for firing the person, that you violated the rule. But I think the more pertinent point is that it's not as though our position inexorably leads to the consequence that you can't have sex-specific grooming standards in a way different than other decisions of this court have already done so. So take, for instance, the Dothard case, right? So in that case, the court held that men who guard, there's a rule that said that men who guard men in prisons and women who guard women in prisons, that rule discriminated on the basis of sex. And that argument would just as inexorably lead to the consequence that you say is an absurd consequence as the argument we're making in this case. Because in that case, too, there was one set of standards for men and there was one set of standards for women. There wasn't discrimination in the aggregate because men could guard men and women can guard women. And yet the court held that that was discrimination. And so,
so counsel, you'd have no problem with transgender discrimination if it were, right? If it was a transgender employee who might be biologically male, grooming herself as a woman, that would be okay to discipline or dismiss that employee.
We don't think so. We agree with the position that's being advanced by the transgender employee in the companion case here. I think it would just depend on the specific standard. Look, I think that as was bandied in the briefs, it seems to me that a rule that said that men could wear suits and ties, but women had to wear sort of revealing clothing, that would violate Title VII without question. I also think that, a rule, for instance, that said women can't wear pants in the workplace, but men can, that might also violate Title VII. I think you have to look at the specific rule. I don't think
counsel, all of those would be addressed by stereotyping, I think. And what I'm really interested in to know is, what does your claim here add beyond the jurisprudence of sex stereotyping? Why doesn't sex stereotyping already cover this?
I think that actually, in many ways, the Price-Waterhouse case resolves this case. It's almost a special case of the Price-Waterhouse case. So the Price-Waterhouse case holds that a woman who was fired because she failed to adhere to gender stereotypes stated a claim under Title VII for discrimination on the basis of her sex. And I think when you read the reasoning in that case, it's pretty clear that a similarly situated man could also have stated such a claim. In other words, it wouldn't have been a defense to liability in that case if the employer had said, well, we fire all women who don't adhere to...
Okay, but here's my question then. If you rely on sex stereotyping, does an employer have a religious defense if it's not a stereotyping basis for firing somebody who's gay or lesbian, but it's based on a religious viewpoint? It has nothing to do with stereotyping behavior. I think it's just a religious view. Is there a religious defense then against stereotyping?
Well, there is the ministerial distinction. I don't think there's a general religious exemption for all employers under Title VII, in the same way that even if employers have a strongly held view that women with small children should stay at home, you can't fire women with small children.
But this would be a constitutional defense.
Yeah,
What's your position on that?
Yeah, so we agree the ministerial exception will apply.
No, that's a ministerial. That's a text-based statutory argument. I mean a constitutional argument for any employer.
Yeah, I think so too. So this court has also grounded the ministerial exception in the Establishment Clause. If Congress failed, there's a debate over whether the statute itself has a ministerial exception. If there wasn't, I think the Establishment Clause would require one. If it's a religious institution...
No, it's not a religious institution. It's just a regular, everyday employer.
Then no, I don't think that the Free Exercise Clause would prohibit, saying that...
You don't think under Hobby Lobby there's some defense based on religion, an employer who doesn't want to hire someone based on their own religious views?
Well, two things about that. First of all, Hobby Lobby applied the RFRA rule, and it's not clear that there's a free exercise clause defense. It might be under Employment Diversion versus Smith. That rule arguably would be a generally applicable rule. And second of all, Hobby Lobby was a closely held company. There's some debate in Hobby Lobby whether it's different from all employers. I do think, though, look, there may be some scenarios in which maybe some small, closely held employers might have a religious objection to employing a gay or lesbian person, and those cases can be litigated. But I think that's not true in the mind run of cases. Look, there's a lot of employers with very sincere beliefs against same-sex marriage who don't think that all gay employees and lesbian employees should be fired.
So in your view, why wasn't Obergefell a sex discrimination case? Why did the court make Obergefell so much harder than it needed to? Because under your logic, Obergefell was a straightforward example of sex discrimination. We should have applied intermediate scrutiny. Done.
Well, first of all, I think that it was just, there's an alternate basis for making the decision.
But that's not the basis the court gave. Why not?
Well, because the Constitution does not explicitly prohibit discrimination on the basis of sex in the way Title VII does. The court grounded the decision in equal protection and due process principles, as in several other gay rights cases before that. It seems to me if the Constitution had just decided you can't discriminate because of sex, that probably would have been the textual basis for reaching that ruling.
Counsel, isn't it, am I correct that every year members of Congress who would be sympathetic to your clients try to change this law to include sexual orientation, and every year they fail? Is that a pretty good indication of what Congress thinks that this law says?
I don't think so, Your Honor. I don't think so. You're right that there have been several failed attempts to add sexual orientation. Pretty much every year. That's correct, Your Honor. But first of all, I don't think that post-legislation activity really sheds that much light on what the text of a statute enacted in 1964 means. It's axiomatic.
Are you saying then that the Congress in 1964 believed that it covered sexual orientation?
I'm saying that the text of the statute covers it, which I think is ultimately the deciding factor. This court said in the Onkel case, and we certainly reiterate, that the laws are what govern us, not the intentions of the legislators who voted for them.
And so what if the plaintiff was bisexual? And what if the plaintiff was a woman, she was bisexual, but she happened to be with a man at that time? What would Title VII have to say about that? Because if you swap it out, and well, what would Title VII?
I think a woman who is fired for being bisexual, that would violate Title VII.
Okay, articulate your reasoning, and would it be different from being fired because you were homosexual?
No, I think both of those people would have a claim under Title VII.
But if you're doing it tagged to the comparator between the male and the female, it just seems like your argument is very binary.
Well, okay, so I first of all, the answer is yes. I think that a woman who is bisexual would have a claim under Title VII because it's still because of her gender. And I think maybe the better argument in that case would be both sex stereotyping and the associational claim. So the sex stereotyping claim would be that a woman who is interested in having relationships with women, even if she's also interested in relationships with men, isn't adhering to traditional gender stereotypes, that a woman should only be in relationships with men. There's also an associational discrimination argument in that scenario, in which you'd say that because a woman wants to associate with women, that's sex discrimination because you're considering her desired association in that decision. So I do think that the arguments we make would also apply to a hypothetical bisexual. If I could just respond to the question a little bit more about what Congress was thinking in 1964. So, of course, it's axiomatic that we're governed by the laws that exist rather than the intentions of the legislators. I think there's actually two reasons in this specific case why that's a particularly salient point. First of all, there's a lot of evidence that actually in 1964, the ban on sex discrimination was a kind of poison pill meant for the whole bill not to pass. That's what the court said in Price Waterhouse. So if we were serious about implementing the intent of the legislators, we'd never apply the statute, which clearly is not correct. And so what the employers are imagining is this hypothetical composite legislator that supported the passage of the sex discrimination bill because of a certain set of views about women and men in the workplace, but also harbored the kind of private biases against gay and lesbian people that hypothesized to have existed in 1964.
The difficulty, though, is that it's not just 64. It's not just that they've tried year after year after year to impose this new classification on the statute. It's not just that they have imposed this classification in other statutes. It's that all those things rolled together just make the argument feel perhaps more clever than right.
Well, I mean, I'm mindful of those points, but I'm happy to go through them one by one. I don't think any of them shed light on what a statute enacted in 1964 means, which turns on the words in that statute itself. So on one of the points you raised that Congress regularly added sexual orientation to statutes, a few things about that. First of all, the reason it did it is because of the argument we're having this afternoon. I think Congress recognized that there was at least a risk that the word sex would not be construed the way we're supporting, and they decided to make it explicit. But I don't think that means that kind of retroactively the statute was, from years earlier, was amended to exclude the protection from gay and lesbian people. Also, many of these statutes recite both race and color, for instance. And the fact that you did that doesn't mean that if you took out color, then someone who was discriminated on the basis of color couldn't assert a race discrimination claim. I don't think that the existence of the two words implies that if you take one out, the second one suddenly becomes narrower.
Counselor, should it give us some pause if we're talking about the original meaning of the statute in 1964, that for decades every court that considered the matter said the opposite of what you're saying, and they were closer in time to the enactment than we are. And the EEOC, which was not famous for timid interpretations of the statute in the early years. I'm thinking of Griggs and disparate impact. They didn't take the view you're taking either until very recently.
So I actually think the history is a little bit more complicated than that. There's an interesting amicus brief by the historians that make it seem a little bit less one-sided. It seems that in the history is a little bit spotty, but in the early years after the statute, the EEOC kind of reached both conclusions. It's not as though no one thought of this argument. Claims were asserted by gay and lesbian employees. Eventually, the EEOC did issue a ruling about a decade after the statute was enacted, which is consistent with the employer's position. But there's just a couple of Court of Appeals decisions that are barely even reasoned, right? Like there's one of the Ninth Circuit case is just all about the legislative history and presumed objectives, arguments that you wouldn't get in an opinion today. And then I think there's the Fifth Circuit case, which has like one conclusory line. And I simply don't think that those cases create a kind of adverse possession on the statute, that what their construction of it is.
But wouldn't Congress have been aware that in many states at the 1964, homosexual conduct was actually a crime? So how could they have thought of protecting one's employment status when they were taking no action to address the fact that there were criminal sanctions in many states?
I mean, it's not obvious Congress even had the constitutional authority to preempt state statutes criminalizing homosexuality. Congress was solving a different problem, which was employment in interstate commerce, and it solved that problem in a particular way. And I think that there's certainly an intuition that in 1964, private biases held by a hypothetical legislator at the time would have created a desire to put in a hypothetical exception into the statute. But I think today, there's not a lot of policy defense on the employer side of the practice of firing gay and lesbian people. And it seems to me that we should follow the text of this statute rather than sort of inserting an atextual exception based on hypothesized biases that don't even really exist anymore.
Well, talking about relying on the text, though, I mean, that's, I guess, where I keep coming back to the stereotyping and why anything beyond that is needed. And perhaps if it's per se because someone's gay or lesbian, maybe that's not covered, but any kind of actual stereotyping is. And then I realize you have this associational argument. What is your best case for that associational argument? Really, that's certainly not in the text of Title VII. Where does that come from? I realize they're lower courts, but what's your best anchor for that in Title VII?
Well, I think there actually is a textual anchor, because if it's based on the sex of the other spouse, it's still on the because of sex in some sense. It may not be because of your sex,
but it's because of the individual sex. That's what Title VII says.
Right. Well, but it does say that. But it's not just the sex of the individual. It's the fact that it's the interaction between the sex of the individual and the sex of the spouse. So it's a similar kind of argument, right? Like, because you're a man in a relationship with a woman, or with a man versus a woman in a relationship with a man, the analysis focuses both on the spouse of both on the sex of the employee and also on the sex of
But have we held that, or is that really just lower court precedent?
Well, it's mostly lower court precedent, but look, all parties agree in this case that firing someone because they're in an interracial marriage would violate Title VII. That's not disputed. The only question is,
race is always the easiest place. What about age? Say you're dating somebody or you're married to somebody who would be protected within the age, but you're not, the age bracket. On the other hand, you think, well, that person's going to want to retire early because their partner is going to retire early. You really think that's covered by the Age Discrimination Act?
Well, I think the Age Discrimination Act itself says that if you're under 40, you can't assert a claim, as I understand it, as an element of the statute.
But what I'm saying, under your associational theory, if that's text-based, you could, based on your spouse being within the protected age limit.
I don't think the associational claim is solely based on just look at the sex of the person you're married to. I think it's based on the association between you of being one sex and the spouse of being a different sex. I don't think it's just looking at the spouse of the other, at the sex of the spouse. So I think there's an analogy to the racial discrimination claim, where the fact that so everyone agrees that firing someone for being in an interracial marriage violates Title VII because you have a right to associate with people of the opposite race.
Have we ever held that? I mean, I know you say everyone agrees, but have we held that? It might violate a lot of things. I'm just asking whether it violates Title VII.
When I say everyone, no, this court has never held that. Mm-hmm. But I think all the employers in this case agree with that. And the argument that's made is not that would be legal, but that racial discrimination is just different. It's more malign than discrimination on the basis of sexual orientation. I'm willing to concede that. I'm willing to concede that you're a bad person if you fire people in interracial marriages in a way that you're not necessarily a bad person if you oppose same-sex same-sex relationships. But I don't see how you can get out of the statute at all. There's plenty of cases that said that even legitimate motives for discriminating violate the statute. The classic example is the Manhart case, where there's discrimination based on the actuarial reality that women live more than men, and pensions were tailed to that. That wasn't malign, it wasn't evil, it was based on mathematics saying that women live longer than men, but it was still sex discrimination.
But we did have Gilbert, right? I mean, the statute had to be amended to cover pregnancy. So, if you look at that rationale, I don't know if your argument holds up.
Well, I mean, I'm not certain that Gilbert would have come out the same way today. I mean, Congress...
It hasn't been overruled, right, except by the statute.
Well, I mean, the question became moot once Congress overruled.
Well, that's not true, because we said the same thing under the Constitution. We said pregnancy discrimination was not sex discrimination under the Constitution, and that's never been overruled.
Well, but the Constitution does not explicitly prohibit discrimination on the basis of sex in the way Title VII does. I mean,
that doesn't work.
It's been construed under
the Constitution doesn't expressly prohibit race in the way that Title VII expressly prohibits race either, so I'm not sure that works.
No, look, I think that Title VII specifically talks about sex, and so I think that you have to follow the text. There's a lot more flexibility. I mean, intermediate scrutiny is a judge-created standard, right, that applies to gender classifications under the Constitution. I don't think you can just insert intermediate scrutiny into Title VII, which just explicitly says because of sex. I think that you just have to interpret those words literally when those are the words that were provided by Congress. But I would like to just say one other thing, by the way, about this notion of in 1964 Congress wouldn't have intended this, because I actually don't think this is a debate between what Congress would have intended versus what the statute says, because we haven't talked much today about how it's difficult to disentangle sex discrimination from sexual orientation discrimination. I actually think they're very difficult to disentangle because for a lot of people, acting effeminate is equivalent to being perceived as gay. But the argument by the employers would require juries to distinguish between those two things, right? Is it really because they were effeminate or really because they were gay? And that line being drawn by juries is not a line that Congress would have anticipated in 1964 either. So I don't think this is a debate between the text and contra to the intentions versus the intentions and contra the text. I mean, both sides imagine a statutory scheme where juries are doing things that could never have been imagined in 1964. And when we're in that world, it seems to me you should go with the text rather than the implied exception to the text that the employees are advocating in this case.
Counsel, can you address some of the limiting principle issues that have been raised in many of the briefs in terms of if this is something that an employee can claim is due to their sex, what about someone with a disability or someone some inappropriate, say, behavior by a male employee, and it's really the behavior that is disturbing the workplace, but that employee under your thesis could perhaps just say, oh, you're discriminating based on my sex, or you're discriminating based on my disability, not the behavior that I'm exhibiting that is disturbing the workplace.
No, I don't think that's the case. I mean, it's hard to see how that would work in the world of sex discrimination. I mean, disability discrimination, it's hard to imagine a specific hypothetical. If someone has a disability that causes them to be incapable of working, there's exceptions in the ADA that would allow the employer to fire the person. There is some flexibility for people who are incapable of doing the job. I'm not sure of, in the sex discrimination context, what the reductio is exactly. And now, maybe this is related to the question you asked. The government's brief talks about, sex-segregated bathrooms or sex-neutral bathrooms is the implication of our position. And I just don't think that's the case for a couple of reasons. First of all, again, I don't think that's an adverse action in the same way that we're saying. And second of all, that's the logical implication of plenty of other decisions of this court already. If you accept the premise that a rule that discriminates against men and that separately discriminates against women can violate the rights of both, like in the Dothard case where men had to guard men and women had to guard women, then you've already accepted a premise that a rule that sort of in the aggregate treats men and women alike but discriminates against individual men and individual women violates Title VII. And when you're in that world, it's not like our position leads to sex-neutral bathrooms in a way that prior cases didn't already lead to sex-neutral bathrooms. So it's sort of this...
Following up on Justice Brinkman's hypothetical before in the ADA context, what if you had a 62-year-old employee who married a 17-year-old spouse, and the company found that distasteful and dismissed the older employee? Would that be an age discrimination violation?
Yes, I think that absolutely would be age discrimination, yes, because pertinent to the decision was the fact that the person was 62 rather than younger. So I would have no difficulty with that. If it was the other way around, if the 17-year-old were fired, I don't think the statute would allow that claim because the statute requires the individual to be more than 40. But that's a classic
example. Have any courts adopted that associational view outside of the race context?
I don't think so. I mean, The sexual orientation litigation is pretty recent. There's only a few courts.
No, I mean even in the age discrimination or any other protected classification.
I'm not sure that's been litigated. I'm not sure one way or the other. But I think your example illustrates how the associational claim turns not just on the sex of the partner, but on both sexes, right? There, the issue is not the fact that the spouse is 17, it's the interaction between the two ages. And if the age of the employee had been younger, the employer wouldn't have fired them. So even though they're being fired because of the association with the 17-year-old, it's still because of the employee's age in the same logical sense that in the argument we're making today. I will reserve the rest of my time. Thank you.
Thank you, Mr. Unikowski. Mr. Gorenstein?
Right this way. Madam Chief Justice, and may it please the court. Title VII's prohibition against discrimination because of sex does not ban discrimination because of sexual orientation. They are two different forms of discrimination based on two different personal characteristics.
Can I ask you just a quick question? And forgive me if I'm oversimplifying this, but would it violate Title VII for an employer to refuse to hire women who, let's say, like to smoke or like to curse, but to hire men who like to engage in the same behaviors? Would that
No, that is exactly what the cases say an employer could not do.
Okay.
And so there you're
This is different.
so there you're
Who like to date women as opposed to men who like to date women.
all right. So the comparison, what the problem is the comparison between a gay male and a heterosexual female. That's the comparison. Doesn't answer the Title VII because of sex question, because it doesn't answer the question whether the difference in treatment is because of sex or because of sexual orientation. And in order to rule sex
But I guess I worry that, is that just conclusory or is that just me? I mean, it sounds like your opponent says, sure, it violates the prohibition on sex discrimination for the same reasons that Newsom's hypothetical violates the.
So, and I'm going to try to explain why I see the difference, why there's a difference, which is in order to rule sex in, you have to rule sexual orientation out. And in order to do that, you have to compare males and females who are similarly situated in terms of their sexual orientation.
But counsel, how does that work with Justice Barrett's question about bisexuality? I mean, if the employee is bisexual.
But if they're bisexual, then they would be, as long as they're treating all bisexuals the same, there wouldn't be discrimination because of sex. As long as they're treating males and females.
So under your theory, if there is a hostile work environment, blatant sexual harassment, so long as men are sexually harassed and women are sexually harassed, no one has a Title VII claim.
So I think that's right if it's the same supervisor who's doing the harassing. If it's
a hostile work environment, it's the environment.
If it's an equal opportunity harasser, that's not discrimination.
And you think that furthers the text and purpose of Title VII?
Absolutely, because this doesn't just prohibit harassing conduct.
But what about such individuals' sex? I mean, this goes back to...
Again, it's as long as you're talking about say a bisexual supervisor who is harassing both men and women.
No, I'm just saying a straight harasser. I mean, in OnCal, there was no suggestion that there was any, it was just sexually based harassment by, I think everybody there was heterosexual. It doesn't have to do with their sexual orientation at all. I'm just talking about no sexual orientation.
The question is it because of sex or is it not because of sex?
Right, so let's talk about OnCal, right? No sexual orientation, all heterosexual, all male. It's on the oil rig. There were no women on that oil rig, right?
Right, but the discrimination was in discriminating against him because of his sex. A woman in the same position would not have been treated the same way.
Oh, that was not the finding of the court, I don't believe. I think they found that the discrimination was of the sexual harassment, and it was sex-based, the discrimination was sex-based. I don't think it was a finding that they wouldn't have treated a woman that way.
Well, so the court never reached a conclusion
That's right,
about
they didn't.
whether there was discrimination because of sex, but it said in order for there to be discrimination because of sex, it would have to be a decision that was because of sex and not for some other reason. And in order to show that there's discrimination because of sex, you have to show that there's a difference between how someone would have been treated if they were a person of the opposite sex.
So if everybody's sexually harassed, your position is no Title VII?
So again, I say, if it's different supervisors doing it, then I think that each one is a different act of discrimination because of sex, and then it's exactly like the Price Waterhouse situation. Let me go back to the Justice Newsom's, sorry.
Just Kev, that's what my kids call me.
Hypothetical, and explain why this is the way the comparison test always works. Take Phillips. What you're looking at is, are they similarly situated in terms of the alternative trait that's been identified? So in Phillips, the alternative trait is young children. So you compare males and females who are similarly situated in terms of having young children. You see males get a job, females don't get a job. Same thing with Manhart. The alternative posited explanatory trait there is life expectancy. So you compare males and females who are similarly situated in terms of life expectancy, and you find that females have to pay more. So here, the alternative explanatory trait is sexual orientation. So in order, you have to...
Alternative explanatory trait was simply the sex of the other individual. Men
No,
who like men versus men
but
who
the
like
policy that's being challenged, what the assertion is being made is that sexual orientation discrimination is discrimination because of sex. So the alternative posited explanatory trait is sexual orientation.
But that seems very strange to me. So so imagine a society, as I gather that some societies have no legal conception of sexual orientation. And your argument suggests that if our society had no legal conception of sexual orientation, then we'd be back in the Newsom hypothetical, where liking to date women is just the equivalent of liking to smoke. And if our society didn't have that category, then it would be sex discrimination.
So I do think we have to take a step back and ask for the common understanding of these terms in this society. And especially at the point of 1964. And there, sex referred to a distinction between males and females.
Are you asking that we overrule Oncal? Because I think Oncal, Justice Scalia unequivocally said, we're looking at the text, not what Congress intended. And we know that sex isn't a binary definition. Whatever people think value-wise or whatever, from time immemorial, ancient Greek society, there is not necessarily a binary sex. It's because of sex that the discrimination is.
So if I could address the understanding in 1964, sex did refer to distinctions between males and females. I don't think anybody disagrees with that who's arguing today. And sexual orientation refers to distinctions between homosexuality, heterosexuality, and bisexuality. So if you...
So are you saying we should is this sort of an originalism versus textualism debate that we're having over...
No, this is actually a textualism debate we're having. So if you had handed the language of Title VII to a reasonable person in 1964 and asked that person, does this statute prohibit discrimination because of sexual orientation, they would have said, no, it's not on the list.
But how would you define sexual orientation without reference to the person's sex? At least if you're talking about homosexuality and heterosexuality. You have to know what the person's sex is in order to...
Right. So the argument that because you have to know a person's sex to discriminate because of sexual orientation, I do think there's two responses to that. First, you don't have to know it. Take an employer who has an application form that says, check the box, heterosexual, other. That employer would be enabled to discriminate because of sexual orientation without having any idea what the sex of the person is.
That's actually slightly different than my question. I'm saying that if the statute prohibits discrimination on the basis of sex, that sexual orientation is bound up in the idea of sex, because to define someone's sexual orientation, at least if you're talking about it in terms of homosexuality, and heterosexuality and putting aside bisexuality or pansexuality. You have to know what your sex is in order to define
So
it.
again, the fact that you have to know what your sex is doesn't answer the textual because of sex question. Because of sex in this statute for a dissimilar treatment refers to motivated by sex. And you can know that somebody has a particular sex, but if you're discriminating based on sexual orientation, you're motivated by their sexual orientation and not their sex.
I just wanted to ask about Meritor versus Vinson and sexual harassment and a hostile work environment. Is your position that in order for women to have a hostile work environment claim, the harasser has to be a male?
No. Absolutely not. It just has to be because of her sex in the sense that...
On the basis, okay, because of the individual sex.
In the sense that the person would have been treated differently had they been a male.
Mr. Gorenstein, let me take you back to Price Waterhouse, though, that Mr. Unikowski had stressed so much, the sex stereotyping. His argument heavily relies on that, and if you could just pivot to the breadth of Price Waterhouse and if you think it would go this far.
So no, because what Price Waterhouse involved is a sex-specific stereotype that a woman shouldn't be assertive, and then that stereotype was applied to deny a promotion to a woman who was assertive when that same assertiveness would not have been held against a male who was seeking the very same promotion.
So the only case that I can possibly see hypothetical that can't be covered by stereotyping is something like same-sex bathrooms. Other than that, as soon as you get into who you're dating, who you're attractive to, that plays right into, well, I expected you to conform with these norms, you're not conforming with the norms. Other than bathrooms, I don't see how all of this doesn't come within stereotyping. And let me just ask you a question while you're answering that. Do you agree with the government's position? Do you agree with the government's position on stereotyping? Because they say that stereotyping is not a violation of Title VII in and of itself. I just think it's tied to that, the answer you're
So I want to say yes, but I hope you won't follow up on it. And let me answer just the other question that the Chief Justice asked me, which is what the stereotype here is a non-gender, or it's a gender-neutral stereotype that everyone should be heterosexual. And the way that stereotype is applied, similarly situated males and females who are attracted to persons of the same sex are treated exactly the same. So that's completely different than the situation in Price Waterhouse.
Wouldn't we say in Price Waterhouse that the policy was the same? It was universalistic, not sex-specific. It is everyone should conform to traditional gender norms.
Yeah, and I think that's not the policy here, that nobody's saying everybody has to conform to traditional gender norms. They're saying they have to conform to heterosexual norms.
So if the employer says lesbian employees are okay, but gay employees are not, is there a Title VII claim?
There absolutely is. That's discrimination because of sex, because similarly situated people who are similarly situated in terms of their sexual orientation are being treated differently, and the only reason they're being treated differently in that situation is because of their sex.
Counsel, is there any relevance to the Obergefell decision and its predecessors that have fundamentally changed the way that the Constitution, the law, looks at sexual orientation? Does that have any relevance at all to this?
I don't think it does, because constitutional interpretation can't affect what the meaning of Title VI was in 1964. And if I could return to 1964, because I think there's another crucial point about it that addresses all of the plaintiff's theories here. And that is, at that time in 1964, practically every state had a prohibition against homosexual conduct, and the American Psychiatric Association had identified it as a mental disease. Now, this court presumes that Congress does not usher in vast social change through language that is indirect and vague on the subject.
Well, let me ask you another question about 1964, because of course that's pre-Loving. So do you agree with your colleague? Your colleagues submitted that everybody agrees that firing someone because of the race of their romantic partner is race discrimination. Do you agree with that?
Absolutely.
Okay, so why is that at all obvious? First of all, that's pre-Loving, so it's not necessarily obvious that everybody would have thought in 1964 saying you can't discriminate based on race means you can't fire somebody for being an
So I actually think it is obvious, and it was obvious to the court in Loving not that much longer, unanimously, so.
But there were states that prohibited it, just like you're saying states prohibited this
But
conduct.
far fewer, and at the same time, the language is absolutely clear on that. And let me go, and whereas it isn't on this, and so let me go to the difference of why these are different. Interracial association discrimination is a form of racial discrimination. It's not based on a different personal characteristic, whereas sex and sexual orientation discriminations are two different forms of discrimination because they're based on two different personal characteristics. And another way of looking at this is interracial association discrimination rests on a belief that one race is better than the other, is superior to the other. Sexual orientation discrimination does not rest on the belief that one sex is better than the other.
What kind of claim is that? Is that a claim about inherent? I guess I'm just not sure it feels to me that the way the court would, at least, I understand there's the language about white supremacy in Loving, but I think the way the modern court would think about Loving, that's just a racial classification. It doesn't matter why you did it. It doesn't matter what your reason was. That's a racial classification.
Right. I do think that it is. That was my the first point I made. The second point I made was slightly different, but the first point I made is that interracial association discrimination is just a form of racial discrimination. It's not based on a different personal characteristic, whereas sex and sexual orientation discrimination are two different forms of discrimination because they're based on two different personal characteristics. If I could make one further point about the legal context, and the legal context is what happens after 1964? And there's two significant developments post-64. First, Congress enacts multiple civil rights statutes that cover sex and sexual orientation separately, as separate categories. And now, under the related statutes canon, you read those related statutes together with Title VII as if they were one statute. And when you look at it that way, it's clear that when Congress wants to cover sexual orientation, it does that through a separate category.
What do you say, though, to your opponent's suggestion that, it also says race or color?
Well, race or color actually are covering two different things. You can have a color.
Some overlap, surely you.
There's definitely overlap, and so the real point that addresses is this belt and suspenders. Is this a belt and suspenders situation? So Congress uses belt and suspenders when two terms mean the same thing or almost the same thing, like cease and desist, and it doesn't want courts to think there's something significant about dropping one out. Here, it's just not plausible to think this was belt and suspenders because at the time, first of all, the ordinary understanding of the terms, as I've said, is that they're two different things. And then every court and the EEOC had said they're two different things. And so when Congress puts them both in, the only plausible inference is that put them both in because they thought they were two different things and they wanted them both covered.
Yeah, but counsel, based on your point about the classification of homosexuality as a mental disorder and so forth, with our air pollution statutes, as new pollutants are discovered or once materials thought benign or discovered to be actually dangerous, the authority to regulate them increases. Right here, we have is this analogous in any way? You had something that was misunderstood as a mental disorder. Many of those views were based on prejudice. As that knowledge has changed, even here on this court, doesn't the word take on its natural broad meaning? It's a very broad term, Zach.
Well, so I think it does take on its natural meaning, but it's always had its natural meaning, and that's the distinction between males and females, whereas sexual orientation had then and has now the same meaning. It's a distinction between heterosexuality, homosexuality, and bisexuality. If I could return to the point of the other legislative development I wanted to get into, which is this. Against the backdrop of an EEOC and Court of Appeals consensus that Title VII didn't cover sexual orientation, and repeated efforts to enact bills that would have overturned that consensus, Congress did the following. It amended Title VII to counter interpretations that it did disagree with, while retaining the discrimination because of sex language that had received a uniform construction.
Counsel, during that time period, though, sex stereotyping certainly was a doctrine that courts recognized and this court recognized to get at discrimination based on, somebody not being feminine enough or being too feminine, right? So sex stereotyping existed throughout that.
Oh, yes, if an employer adopts a policy of treating effeminate males less favorably than effeminate females without regard to their sexual orientation, that's discrimination because of sex. And similarly, it would be a separate act of discrimination if
Why does it have to be without regard to? Why can't that be a factor that's considered in the stereotyping analysis? I would certainly think that our precedent would allow that to be evidence that would be relevant under your reading of Onkale even, or Vincent, it would be relevant, even perhaps not under your view dispositive, but it would be relevant.
So I'm not going to say evidence isn't relevant, but the ultimate question for the jury will be, was this because the person was effeminate, or was this because the person was not heterosexual?
Wasn't conforming to stereotypes based on sex.
I would say if the reason is because the person is gay, that is discrimination because of sexual orientation. If it's because the person was perceived as effeminate, that's different. Now, the point has been made that this is a difficult factual inquiry in some cases, and I'm not going to deny that that's true, but there are other comparable, difficult, practical inquiries that have to be made under Title VII and related statutes. For example, alienage and national origin. A jury has to figure out, is it alienage or is it national origin? In 1981, you have to figure out whether it's ancestry or is it national origin. One's covered, the other isn't. And in every Title VII case, the reality is, unless the plaintiff has either direct evidence or a similarly situated comparator, the plaintiff is going to have a difficult time proving that the discrimination is because of sex, and that's in every case.
Counsel, can I make sure I understand your position on our bisexual worker? She dates a man, everything's fine. They break up, she dates a woman, she can be fired.
Based on the fact that she's bisexual, yes, and the reason is...
Started dating a woman, she can be fired, and you think that that's what statute that was intended to eliminate discrimination in the workplace?
Well, not all discrimination in the workplace, just discrimination because of sex and the other categories that are identified there. And in your hypothetical, yes, the person knows the sex of the person she's with, and from that, she infers that she's bisexual. But the question is, the because of sex question...
What she was taking.
No, I would say that what she knew, the employer knew, was this statute only prohibits discrimination because of sex, and that means action motivated by the person's sex. And this action that you referred to was not motivated by the person's sex, it was motivated by the person's sexual orientation. And as long as she treats the employer, bisexual males and bisexual females, the same way, that's not discrimination because of sex, that's discrimination because of sexual orientation.
Counsel, you keep drawing this distinction between because of sex and sexual orientation. How can you be so sure that they're such distinct categories? Why isn't one's sexual orientation bound up in and go hand in hand with as an expression of one's sex?
So, Justice Barrett, I think first I start with the fact that these are two different terms with two different meanings. Males and females, and bisexuality, homosexuality, and
so the word sex appears in both.
Yes, but it's and you know, there was the original argument, by the way, just to refer to the EEOC's initial position and what it struggled with. What it struggled with was whether the term sex referred to sex as we normally understand it to mean males and females in this context, or whether it was talking about the physical act as well. And if it was talking about the physical act of sex as well, maybe it would include sexual orientation discrimination. But then the EEOC came to the conclusion, rightly I would think, that the use of the word sex in Title VII, along with all the other characteristics that it's standing with side by side, is referring to the difference between males and females
what do you
and
say to Judge-
not the sexual act.
Judge Katzman's opinion, which I think is very much along the lines of Justice Barrett's, that sex or orientation is a function of sex.
Yeah, so by a function of sex, what the judge meant in the Second Circuit was that in order to discriminate because of sexual orientation, you have to know the person's sex first. I've already made my point about why I don't think that's so, but let me assume it's so. The statute doesn't prohibit knowledge about sex, acting based on knowledge about sex. It prohibits discrimination because of sex, and that means discrimination that is motivated by the person's sex. And as the court said in the Abercrombie decision, there's a difference between knowing about somebody's characteristic and being motivated by it.
Go back, because I think this actually turns out to be surprisingly important for me. So would you agree that if our society did not conceive of sexual orientation as a separate identity, this would be discrimination based on sex?
So it's hard for me to think about that, but I do think the basic thrust of my position is that these are two and have always been understood at, and certainly were understood in 1964 as two different personal characteristics.
The difficult thing, I think, is you said in response to Justice Barrett, this is sort of a merging of Justice Barrett's question, Justice Hyten's question, and my initial question, is that you said that there are two different concepts, but the only concept that we care about here is the one that the statute mentions, which is sex. So I think we are in Hyten's land, and you're the one who keeps trying to impose this external category, sexual orientation, onto the statute. All we care about is whether this is discrimination on the basis of the individual's sex. So I think you can actually forget that there is this thing out there, sexual orientation.
So if I
You can answer the question. Briefly.
So I do think that you still come back to whether it is because of sex, and in order to decide that question, you have to ask whether it's motivated by the person's sex. And the fact that you're aware of the person's sex doesn't show that you're motivated by it, and what proves that you're not motivated by it is that males and females who are both attracted to persons of the same sex are treated the same way. Thank you, Your Honor.
Thank you, Mr. Gornstein. Mr. Unikowski, you have 3 minutes.
Thank you, Your Honor. I'd like to make 2 points in my rebuttal time. One having to do with this concept that sex and sexual orientation are different things, and one about the equal opportunity harasser. So on the first point, it's true in a trivial sense that sex and sexual discrimination mean different things. They're not synonyms in any relevant sense. And we're not saying that they are. All we're saying is that when you discriminate on sexual orientation, you're also discriminating on the basis of sex. So just to give an example, suppose an employer had a rule saying all mothers are fired. So that would clearly violate Title VII. But that doesn't mean that motherhood equals sex. Those are fundamentally different concepts. It's just every time you're firing a mother, you're firing a woman with children, and therefore you're discriminating against women and in favor of men. And it's the same thing here. Every time you fire someone on the basis of sexual orientation, the fact that they're of a particular gender attracted to someone of the same gender is factored into decision-making. So it's just one type of discrimination on the basis of sexual orientation that inexorably leads to a different type of discrimination, which is discrimination on the basis of sex. And the second point is about this equal opportunity harasser. And I wasn't sure exactly the response of my colleague in this case. At one point he said that maybe if it was the same supervisor, there'd be one rule. If it was different supervisors, a different rule, which is hard to locate in the statute. But it seems to me that there just is no good answer to that question. So if the answer is no, if equal opportunity harassment does not violate Title VII, then that's a pretty remarkable result. First of all, you're effectively overruling Price Waterhouse, because you're in a world where as long as the employer that sex stereotypes of women and also men, they escape all liability, which is completely inconsistent with the reasoning where that would be more sex discrimination rather than less. You're in a world in which racial discrimination or racial harassment of one race is excused by racial harassment of a different race, which I don't think Congress would have intended. To me, that result is just inconceivable based on the reasoning of Price Waterhouse. But if the answer is yes, if the equal opportunity harasser does violate the rights of both the woman and the man, then it seems to me virtually all of the arguments of the employer go away. Because first of all, the argument of the employer is we're treating men as a class equally to women as a class. Same thing in that case, right? You're treating men as a class equally to women as a class. You're harassing both. The argument by the employer that that inherently anything that the comparator group should be men who are attracted to men versus women who are attracted to women. Same thing here. You'd say the comparator group is men who are effeminate versus women who are overly masculine. There's both being fired, and so there's no discrimination. And so it seems to me that those arguments, if you don't agree with them in the context of the equal opportunity harasser, you also shouldn't agree with them in the context of sexual orientation discrimination. And in fact, we think that, as I said in my earlier remarks, this is just a special case of Price Waterhouse. It's just one way of being gender nonconforming is to be attracted to someone of the same sex. Look, I seriously doubt that Price Waterhouse would have come out the same way if the employer said, well, our defense to liability is that Ann Hopkins was acting too much like a lesbian. That seems very unlikely it would convince the court, and yet the implication of the employer's position is that that would have been a complete defense to liability. And without further ado, I rest my
Thank you, Mr. Unikowski. The case is submitted. Okay, we're going to go deliberate and do what the court usually does over 4 weeks in 5 minutes. So actually 10 or 15. So it's a break time and we'll be back to give our ruling. Thank you.
You always have to pull this one out. It's kind of like that game Rush Hour where you have to move all the chairs and cars around.
Of course, some justices could put in their chairs before they left. It's the books. Hey there.
There's a super job things in the back, the flaps.
I am wearing it.
It's a gorgeous suit, but I just thought you might want to know. It was like watching ducks. That was
So that was interesting.
How's life?
I don't know how.
it's helpful to see what people are asking.
Thinking.
Yeah. They're looking and asking.
Hey there.
You never had to answer for Dothard.
I have my Dothard answer.
What's your Dothard answer? Yeah.
What Dothard did was a situation where males were explicitly closed out of certain positions and females were explicitly closed out of other positions. And here, males and females who are attracted to sex were closed out of all the same positions.
Yeah, I mean, I think that's the
I would have given it, but
I was just curious.
there was so much. I mean, if I would have had time, I would have gotten to Gothard. But once the thing is, you can pierce that in a lot of different ways. But there's nothing I don't think anybody could have come back with after I said that.
Yeah.
I mean,
it will be a really interesting moment in the argument as you have hypothesized or tried to encourage the court to ask, which is if one of the employers is asked, like, are you an equal opportunity discriminator? I mean, it's like they have to say yes.
That was the one question I was questioning myself about after I said that. That was the only one, but I felt like I had to take that position if I was representing that side of the case. I would have liked to figure. I had more time to figure out a way to do it.
Right.
Which I did with the different supervised arguments.
Right.
I was going to
change the hypothetical.
Yes, I was always going to do that. But I feel like if it's the same supervisor, it's not because of. I have to say it's not because of sex. It's bad, but it's not because of of sex. I think that has to be that.
I think they had.
With a different supervisor, I felt like those are.
Oh, yeah, right.
Because each is an act that's
Right.
attributable
Right.
to.
Right.
And so that becomes Price Waterhouse,
Right.
like even from my side.
Right. Right. And they let you off the, why can't you describe Price Waterhouse as failing to conform to gender norms? They let you out of that pretty easily. I think that might be, that's I think, a one to push harder on if you're justice on our side.
So, the whole thing about that is, I stayed with, I had the two prongs that I was going to have to land on one I would. Just as long as you're treating them because I'm feeling sexual orientation, that's that.
Yeah.
And a lot of this does, as they were telling me, the argument on my side does depend a lot on them being viewed as two different personal characteristics.
View of what?
Viewed as two different personal characteristics because it helps to distinguish race, I think, and various other hypotheticals. So anything that is sexual, in my world, anything that is sexual orientation discrimination can't be sexual. That's what it is. So you just divide the world like that way. And I think otherwise.
It also feels weird to give the answer, which I think is also the answer you have to give, that if you fired only lesbians and not gay men, and that feels like you pause over that answer, but I think it again has to be right.
Oh yeah, that's definitely
but
right.
It's,
that's definitely right. That has to be the answer. And one of the things is in '72 when they were trying to get the Equal Rights Amendment going, and somebody was trying to scuttle it by saying this would create a right to same-sex marriage, and the response of the sponsors was no, it wouldn't, but it would prohibit you from only one rather than
letting men get married but not women.
Right. So I felt like that's
something. It's one of those things that's it's logically correct under their view, but it feels like it's not their real. It just feels funny, which is a good thing to bring out.
Do you guys think the transgender case is different? The case of the transgender employee. I mean, that's a hard one for the
harder
person
for
comes,
the employer.
An employer. I mean, the person comes to work as a male is fine. Comes back to work on Monday as a female, and then okay, you're fired. It sure seems like.
So I do think. So here's the thing. Transgender feels a lot closer as a characteristic to sex than does sexual orientation to me. But the arguments that are being made in the trans case are just identical to the arguments that are being made in this case, more or less. Do you think they're different? I don't know. They seem.
Well, I think you're right that they're very similar. They could have been written differently. It could be more space. The case could have been briefed to have more daylight between them. The question is whether the justices would try to separate, do anything like that.
But are they treating them as two different issues, or one issue?
No, two.
Yeah. That case is getting a whole separate argument.
So the trans one also has this dress code question working in a way. I was so glad that nobody tried to make me defend that dress code nonsense that the government was saying separate bathrooms. I was going to tell them if they asked me. I know, that's the problem. It just seems so easy to answer. Why do they?
Maybe they think that's the boogeyman.
They do. They obviously do.
Yeah.
Because it's their answer to everything. The SG's answer to everything.
Maybe they know something we don't. I don't know. But yeah,
I probably overstepped with that, but I just like to. So it's not going to dominate.
Because of you going into it, what's the vote lineup on this? 5-4 or something? 5-4 or something other than 5?
No.
Everything else good?
I also don't understand that expenses. I don't understand those things, because for me, and why the bathrooms don't matter, bathrooms are definitely because of sex. And so the question
To
here
go the
is,
other parts of the statute.
right, and so like this, it seems to me that, the argument for the employer is this isn't because of sex.
I know. Well, to me, the bathroom thing reminds me of like Sutton and cases where they the court has sometimes just been so afraid to let things in the door that they just artificially keep them out of the gate. And so it's not like the court doesn't make that move sometimes.
So
but
Adam,
it's just
Adam had an interesting idea about that. I just thought that what he didn't qualify. It was like he said, you've already decided.
I know, but he should. I know. I would not have put that point.
Right. The point is there to be made. No, you don't. But you don't say what you're no more there than you are in those cases by flying here, and you have the same answer that you have there as you have here. But he made it seem like. He didn't mean to do that. I know he didn't mean to do it. Yeah, but that's what I got care of it. I thought, they're going to have a convincing. We've already decided. But there's a way to put that point, I think that's useful. Yeah. It's you've already decided something. And then you have to decide something else.
I liked your spin on the 1964 thing in Congress with it, but Toby's coming back pretty good. I was loving him. I mean, and you said the right thing too, but it was enough to take the air out of it.
Hello, hey Ken, how's it going?
Hey there.
Sorry to see you.
No worries.
I've seen one or two of your videos over the
Yeah.
years.
Yeah.
Good to see you. How are you?
Not too much.
Excellent. Great.
Couldn't be done with this, I'll tell you that.
Yeah, I was very sorry to lose that.
All right. She went to Jeff's place.
Oh.
SNC.
Oh, the other.
Don't blame me.
No. Maybe she thinks she's coming.
How's the new operation?
So far, so good.
Yeah?
Up and running. Good. So I'm kind of overwhelmed, actually.
Posture
out right. Yes. Yeah. I get to play right in the practice, but we don't have very many associates.
I see.
So we're kind of scrambled. But it's a good problem.
How big is the office?
That's 70, gosh, 80 fall.
Yeah,
so yeah, it's good. How are things with you?
Things are good.
Coming up.
Yeah, some irons in the fire. I always feel like this conference is like shaking me into action. And my mind going.
Okay, we're going to start again.
Everything's classes are 2 weeks in, so
If everybody could sit down, please.
getting this thing out of the way, let me tell you, don't do it if they ask you.
I feel like it's like a hazing ritual.
It's
Like everybody has to do.
It's like a time slot.
Down there getting ready to adding new cars in. Excellent. Great. Yeah, I think I managed
It's an incredible What's happening now? What's happening now?
Oh! Yeah, instant gratification.
I'm going to be shocked. I think I got 2 votes.
I think your side is going to get more votes in the real court.
Oh, I'm not going to do another panel. I don't have a scissors.
All rise.
First, thanks so much to our advocates who are excellent. We have a ruling to announce, but first, I just want to stress again the educational nature of this and how none of us have voted necessarily our points of view or how we think the justice will vote. We have actually a bad track record when it comes to the justices. But the main thing we want to stress is how good it was, and to prove it, we have gifts. First, Adam and Irv, we just want to give these to you before we tell you how we ruled. Bravo, bravo. And this is on behalf of Wilson Mary Law School. Thank you. And we have the court has split 5-4 in favor of the respondent. And Justice Braven will have the opinion for the majority, and then Justice Heitens will announce the dissent.
We have no doubt that the Congress, the past, and the president who signed the Civil Rights Act did not have this type of category in mind at the time. I mean, President Johnson himself famously dismissed his own aide, Walter Jenkins, because of his sexual orientation. And if the president wanted to reserve that right to himself, we cannot think that he would seek to deny that same right to employers in general. Looking more broadly, we have to think about the backdrop of the Civil Rights Act and the restraints it places on employers. The baseline in our free enterprise system is the freedom of the economic actor to do as he or she sees fit. There are times when that should be restricted or regulated for the public good, but we believe the default is for the freedom of the individual actor rather than the restriction, no matter how benign or how beneficial we individually may think that restraint may be. So, absent an explicit announcement or pronouncement from the Congress that sexual orientation is a protected class, we decline to extend the meaning of Title VII to that class at this time. And we think that this distinction is important in light of our decision earlier today in the Harris Funeral Home, where we found that by the same vote, that discrimination against the transgender employer was clearly an instance of sexual stereotyping that we have long held is prohibited under Title VII. So and we invite the Congress, if they disagree with either of those decisions, to make its views known through appropriate legislation.
Thank you. And this dissent feels so strongly, it will dissent from the bench.
We think this case is a straightforward application of the text of the statute and our precedents, both of which would independently support the conclusion other than that the majority reached. First, when it comes to the text, we have heard no persuasive argument to the idea that if you fire someone because of the sex of their significant other, you are doing so by reference to the sex of the individual. And so we think that although the employer argues that sexual orientation is this separate category, we think that takes a category that, regardless of whether it exists in some abstract sense that is not in the statute and inserts this into the statute. So we think this is textually the same thing as firing the female employee who smokes and not firing the male employee who smokes as a matter of text. In response to the argument that that's not what the people who wrote the statute would have anticipated, this court has repeatedly said we don't look to the subjective intentions, we look at the words they used, and we think the words they used resolve this case. Separately and independently, we think this is resolved by Price Waterhouse and our sex stereotyping cases, specifically the equal opportunity harasser hypothetical and a variety of the others that we think, regardless of whether we think the text of the statute resolves this, we independently conclude this is an example of sex stereotyping, that discrimination based on sexual orientation is necessarily sex stereotyping, and as a result, the four of us have noted our dissent.
Thank you. We thought, given the quality of the advocacy and just the general nature of how tightly this case might truly end up being decided, that some people might have questions of Irv or Adam who prepared the case or any of the justices up here. How much time do we have, Neil?
10 minutes.
Okay, if anybody has any questions. Well, then we'll have a break. Thank you again. And as I just want to, since Irv, you hadn't argued before this in Williamsburg before, have you, with this?
No, and I never will again.
The only reason I wanted to just add this, pretend we're now out of our robes, this was the first time Adam had even come. So I just want to say that it has nothing to do with, in fact, we had a lot of switched votes in conference. Let's just put it that way. So thank you so much for the time and effort that goes into this. A couple of the pretend justices up here have argued it, and so much of the argued at other sessions, and so much of our conversation had to do with how hard that is to put oneself on the line. So thank you again, and thank you all for being here. And the next panel will start in about 7 minutes. Thank you.
I liked it. Good. I liked it. This one isn't going in.
Those were amazing. It's kind of thing where you're like, oh my God, I should answer.
We got it. Yeah, okay. We're good.
You want me to spread these out? Oh, yeah. Okay, I'm done. Great job. Maybe you want to do
It is in some way, it's like scarier. Fair, but they
Don had a family issue. His wife broke her hip and he had home care for her, but it fell apart. Well, how are you? I'm fine. How are you doing? More importantly. Great. I can do it. Once I have a quorum.
Hey, how are you, David? Good to see you. How are things? Excellent. Great.
Hey, David. I never saw you. How are you, sir?
How's Battle?
Good.
Send her my love, please.
How's your crew?
Everybody's great. I have a 2-year-old and a 4-year-old grandchild that live 10 minutes from us.
Oh, that's fabulous.
Only makes being here slightly more painful than it would otherwise.
It's your back. Picking him up. Chasing around.
Well, I'm not picking up the 4-year-old. That kid he's huge. That is not happening.
So our 2-year-old had his first day of preschool today, Country Day School, right around the corner from your old place. And he apparently had a great time.
Oh, good.
As you know, that's basically a playground with a
trying to look like.
Which is fine.
Yes.
They're secret to children of a certain age. That's exactly what they should be doing.
For calculus yet, so I think that's all for the day.
That'll be another year.
Yeah, exactly.
They even upgraded.
I've been instructed to start, but I think they should be able to hear us.
I could do this in 10 seconds because I have a voice like a father.
I don't know.
I don't think so.
I'm trying to show a newfound level of maturity.
I didn't think the mic was working when,
Should we do it micless?
when Neil was, but nobody could hear him. So I don't. So the answer is no. We shouldn't do it micless because there will be a problem.
Everyone's trying to do it. Simmy? Hello.
You want us just to talk really loud? You just can't hear it. Oh, okay. Hold on.
They just can't hear it.
Allie, can you hear me? All right, let's settle in. Welcome to part 2. I'm Adam Liptak. I cover the Supreme Court for the New York Times. I'm here with a murderer's row of Supreme Court experts and a target-rich environment in the current court. So we are going to have a very interesting discussion. I'm going to try to stay out of the way and let these experts tell you what's going on. With me, they need no introduction, and we'll get only brief ones from me. Ken and Shem again of the Paul Weiss firm, Carter Phillips of the Sidley Austin firm, Pam Carlin of Stanford, David Strauss of the University of Chicago. Between them, I did the math, they've done 9,000 Supreme Court arguments. Carter has, you can say in private practice, whatever the criterion is, the answer is Carter Phillips. So just this week, we had yet another shadow docket, emergency application, unreasoned order affirming a major Trump administration immigration initiative, second one of the summer. We had Joan Biskupic's very interesting reporting about switched votes, not only in the census case, which was seemingly apparent on the face of the decision, but also in the Gundy case, which remains inexplicable. And so I'm hoping we'll get into some of those things, but let's start at a broader level of generality. We have now in John Roberts, for the first time since 1937, a Chief Justice who is also the median justice, who also sits at the court's ideological center. And I wonder, I'm just going to go from Canada and across the board. What have we learned about John Roberts in this term? Are there surprises? Is his newfound power being used wisely? What do you think, Kenan?
Well, thank you, Adam. I guess I'm the first one who gets to swing at that fastball. It's great to be at William & Mary, as always. I think, I'm going to weasel out of it. I'm going to duck out of that fastball a little bit and say that I think it's a little bit too early to know how his role has changed. I mean, in part because the court had, an uncharacteristically low-key term last year and didn't have a lot of cases in hot-button areas where the chief's vote might have been the vital vote. Indeed, you really did not see the sort of stereotypical 5-4 breakdown on the court that we've kind of come to know and love in recent years. And if anything, I think the interesting fact from last term was that the justice who was in the majority the most often was not the Chief Justice, but in fact Justice Kavanaugh, and that is often one measure of where the center of the court actually lies. And last year, Justice Kavanaugh seemed to be there in a lot of areas. He voted most frequently with the Chief Justice, and I think that there are some ways in which the two of them are very similar. And so I think this term is going to give us a lot more data with regard to the Chief, because the court has a number of cases in hot button areas that I'm sure we're going to be talking about over the next 24 hours already on the docket, and a number of other cases that are sort of in the pipeline that could be added to the docket. And so we've come to expect blockbuster Supreme Court terms in recent years, and I think this year will represent a reversion to that norm.
Carter, would you also like to do a too soon to tell version of the answer, or?
Well, I mean, it's obviously too soon to tell because you didn't even have a full term with all 9 of them on the court at the same time. And to me, at least, it'll be at least as interesting as these things play out to see to what extent, what is the basis on which someone on the liberal side seems to be able to coax at least one other person from across the aisle to join along with them in a variety of different contexts. So that, I mean, that was a pretty remarkable trend last term. Whether that can continue for the foreseeable future or maybe even be increased some is in some ways an equally interesting development. As a guy who clerked for a Chief Justice who was not in the middle of the court and still gets called the burger court regardless of that, I'm not sure, frankly, how important it is to have the Chief Justice be the pivot, and it's just as plausible that Justice Kavanaugh will in fact be the pivot. It's just the distance between them may not be all of that significant, but there'll be a certain number of cases in which it may make some difference. My guess is you'll have 2 in play in a way that, where I used to always say, so it's 4-4, wherever Kennedy comes out is where it's going to come out. It's sort of 4-3, and I don't know where the Kennedy and where Roberts and Kavanaugh will come out, and we'll have to figure that out as usually after oral argument.
Pam, does that sound right to you, that we have a new soft middle of the court made up of Kavanaugh and Roberts?
Well, I think it depends on the issue. The thing that I want to point to that I think is important about the Chief Justice is he's very much a kind of institutionalist, and he's concerned with maintaining the court's position and the court's kind of political capital in the American ecosystem in a time of immense polarization in the other branches of government. And so I think one of the things that was telling this past year is they tried to avoid taking cases that made them look as if they were in the midst of partisanship, and the 2 where they were really forced, in essence, to take them, which were the redistricting cases where they're forced by the jurisdictional statute to take those cases, and then the census case. I think the Chief's, a lot of what the Chief said in his opinion in the Rucho case is designed to say we are not a partisan institution. And so I think a lot of what he's going to try and do is make the court seem as nonpartisan or apolitical as he can. And he has a bully pulpit in which to do that because he has the signing power. And obviously he has some sway over what the court takes and doesn't take.
David?
I'm going to agree mostly with Pam, although I'll go a little further, I guess. I think the Chief is pivotal. It's going to be pivotal going forward. I don't have a good sense of Justice Kavanaugh, but it is pretty clear that 3 of them really want to do some stuff. They want to overrule some precedents and really want to move the court, move the law in a certain direction. They don't seem interested in just kind of going along in a relatively incremental fashion. At least 3 of them want to do that. My guess is Justice Kavanaugh is closer to them than he is to the sort of more traditional, let's decide these issues one at a time, let's not go too fast. The Chief Justice clerked for Henry Friendly, and he's still got a lot of Henry Friendly in him, I think. That, the old, sort of old-fashioned, small suit conservative judge. And I think that's going to be the battle. How fast do they move? How many precedents do they concurring. There are already signs in some of the opinions, obviously Justice Thomas's opinion, also some of Justice Gorsuch's opinion. They're laying the groundwork for overcoming some precedents. And I think the chief will be the one who decides how fast they move in the future. I agree with this. We haven't seen enough of this stuff to tell for sure, although there are signs. But that's where I would locate the ballpark.
So the last time new justice was in the majority more often than any other justice was David Souter, which might be scary to some. And it does seem, at least in the early going, that Justices Kavanaugh and Gorsuch, who look so similar on paper, they went to the same prep school, they clerked for the same justice in the same term, they were both on the circuits for about a decade, they were both favorites of the Federalist Society, turned out to be a little different on the court, right? And voted together 54% of the time, barely ahead of Kavanaugh and Breyer, and Kavanaugh and Kagan, about 46% of the time. What can we say so far, Cannon, about how these two justices differ?
I think that in some ways there are different kinds of conservative justices, and I use that label as a sort of advised shorthand because I do think that methodologically there do appear to be some differences. I would say that Justice Gorsuch is much more of a Scalia-Thomas sort of conservative justice. I think a fairly consistent devotee to the originalist and textualist methods of constitutional and statutory interpretation championed by Justice Scalia. I think that Justice Kavanaugh is somewhat more pragmatic. I think he would describe himself as an originalist and textualist, but I think he is more willing to use a broader array of interpretive tools. And I think at his heart, he is very much more of an institutionalist. And in that regard, he's sort of closer to the Chief Justice. And then you have Justice Alito, who I don't know that I would be as quick to lump together with Justices Gorsuch and Thomas as David was, because I think that Justice Alito is in many ways an old-fashioned Rehnquist-style conservative in many ways, perhaps more of a believer in stare decisis, much more of a sort of a law and order conservative, and you see this schism not infrequently now in the court's criminal cases, where you have Justice Gorsuch often crossing over in much the same way that Justice Scalia did to join the Democratic appointees on the court. And so I think what you're seeing, I think the dynamic on the court is similar to the dynamic that we've seen for a number of years, in that the 4 Democratic appointees are increasingly voting more in lockstep, and there are genuine methodological differences among the 5 Republican appointees. And I think that's what causes the dynamic we saw last term, where, as Carter says, you had, perhaps one of those conservative members being picked off or more in particular cases and quote-unquote crossing over. Now, whether we will see that if the court has a term with more hot-button issues, I think is very much an open question. That was very much the dynamic last term.
What are you seeing, Carter, with the two newest justices?
Well, I mean, it is pretty clear to me that Justice Gorsuch is quite comfortable sort of being linked on some pretty fundamental issues with Justice Thomas, and in ways that are probably a little unnerving, at least for those of us who are advocates before the court, because it's tough enough when you think you know where the precedents lie and trying to sort out what you're going to argue, when you're told at the beginning that actually at least a couple of the justices are going to start from square one. It changes your frame of reference, at least to the extent you think one of them might be the 5th and deciding vote. To me, the big issue as an advocate that going forward is going to be this question of how is the court going to deal with stare decisis, and are we going to fight this? I mean, it seems like almost everything is fair game. The cases that the court decided to overrule this term, I mean, Nevada versus Hall, I mean, that's a venerable case because it was the year I clerked. So that shows you exactly how venerable it is. I mean, if he'd sat around and asked me 10 years ago, what are the chances the Supreme Court's going to rear its up and take down Nevada versus Hall? I would have said 0. Who cares? It shows up once every decade. I can't imagine that it's a hotbed. But the court, found it. Somebody raised it directly. They granted certiorari on it and overruled that decision. So to me, I'll be interested to see if Justice Kavanaugh is that sort of cavalier in dealing with a lot of different precedents, even though obviously he went along with that one. But there's a part of me that says I'll be surprised, and that's one of those places where the two of them will clearly diverge now and into the future, I think.
I mean, it was interesting, last term, the court took 4 cases where the sole question presented was, should we overrule one of our prior precedents? And you'd think that just in terms of vote counting and thinking, they wouldn't take a lot of cases to say, are we going to overrule these cases? And then say, nah, not so much. And yet they only actually overruled the prior precedent in 2 of the 4 cases. In one, they kind of hollowed it out, and in the other, they reaffirmed it. And so this question of, strategically, if you want to get rid of a precedent that's on the books, do you press right now to overrule it, or do you try to sort of nibble away at it in a bunch of ways over time? Is a strategic question for the justices who want to change where the law now is.
What do you think of the amount of argument that goes into the law of stare decisis? Because it seems to me that if someone is hell-bent to overrule a case, they're going to work the stare decisis factors as they want to. And the precedent on stare decisis is not going to guide them.
So you're talking about like meta stare decisis,
Yes.
the stare decisis of stare decisis.
I think he's talking about result-oriented decision-making.
I'm talking
Oh,
about
I'm trying to be highly theoretical.
law professors.
No, I mean, obviously, if you really think the precedent was wrong, the number of times that a justice says, I think this is a terrible, terrible thing, but I'm going to stick with it, is pretty low. That is,
Although Justice Stevens would say that.
Yeah, no,
Frequently, actually.
Yeah, no, there were a lot of cases where Justice Stevens dissented, and then once the court decided the issue, I mean, the biggest one being affirmative action, that he was in the dissent in Bakke on whether you could have affirmative action at all, and yet the court having decided it, he never went back to the issue.
David, what are you seeing with the new justices?
Yeah, I think, and on this question of stare decisis, I agree with Adam that the kind of boilerplate they trot out about the stare decisis factors is kind of useless. I do think that it's possible to make a more or less compelling case about how disruptive it'll be to overrule a precedent. I think there's room for argument there. As far as the new justices, I guess I sort of want to half agree, half disagree with Cannon. I mean, I agree that Justice Alito has a different kind of rhetorical pattern than Justice Gorsuch for sure, and maybe Justice Kavanaugh as well. But gee, I don't see him as being a sort of devotee of precedent. I mean, he campaigned to bring about the result that he brought about in Janus. There was no sort of hesitancy about that. As Pam said, they took some cases where the question was, should we overrule this precedent? They only did it twice, but I think you're going to see more and more. I know of at least anecdotally, at least 2 cases up there now with the question presented is, should the court reconsider this fairly major case, Employment Division against Smith and Hill against Colorado? I just happen to have stumbled across those. And I think, the word is out there that you can ask for some of these cases that have been kind of criticized a lot in conservative legal circles, and you can ask them to be overruled. Now, there is a risk of going too far too fast, but I think that is very much up for grabs in future terms. And I think the chief will be the brake. I don't see Justice Alito being the brake, and I really kind of doubt Justice Kavanaugh will be a brake, although I think he may give the chief some cover sometimes.
Can I say just a couple of things in direct response to that? I mean, the first is that Justice Alito has had a couple of these sort of short, separate opinions, including his opinion in Gundy, that I think are sort of these, slightly snarky opinions that sort of say things like, maybe this doctrine is questionable, but this isn't the right case, or, I thought that Chevron was still the law. He's had a few of these opinions that I think reflect at least some sense that stare decisis plays a role. But you're right, there have definitely been cases where he has, himself called into question the court's past precedents. On the issue of how litigants are approaching this, I do think that part of what is actually happening is somewhat more innocuous, which is that the court in a number of cases has sort of said, well, we might overrule this precedent, but no one's asked us to do it. And so, you've got to put that into play. If you're representing a party and, one of your routes to victory is overruling a past Supreme Court precedent, if you don't frame that as an issue in your cert petition, you run that risk in litigation once you get to the merits phase. And I think that is part of what is going on.
But they induce it. I mean, by writing opinions that say, we don't like this case. But
In an
nonetheless,
appropriate
we'll-
case, the court
Right.
might re-examine.
Right, I mean, they're inviting that from the.
Yeah,
no, I think there's a
But I don't-
certain.
But that's true, but that one, and that's easy, that's a layup. I mean, if a client shows up at your doorstep, 2 years ago, it showed up, in fact, the client did show up mine 2 years ago, and said, we lost this case because of our deference, and what do you think we should do with it? And I said, well, you should go tell the court they ought to overrule our. And then the administration changed the rule 2 days later and gave us back the win gave us the win that we were gonna lose, so we lost our hourish. But, that's easy, that takes no genius to say, go ask the court to overrule an opinion that they have, 5 of them have said at one time or another, they think it was a ridiculous rule. Even if they, at the end of the day, didn't decide to overrule it when the time came. I still think, though, for most advocates, something that I didn't do, at least in the first 20-some years that I was practicing law, was think in terms of precedents that you would take a shot at, and under what circumstances, and how do you play that? Because that would have seemed very provocative to come in and say, I think you ought to think about overruling something. Not that they wouldn't. Some of it's driven by when the court tells you that, but I think you have to at least have in mind, are there doctrines that have been criticized, and then what are you going to do about them, and how far are you going to go? I mean, I'm assuming now, after the Tennessee wine case, that court's not going to come back and deal with dormant commerce clause, but who knows if somebody wants to raise that one again down the road.
David, let me ask you about a distinctive feature of this last term, and indeed of the Trump years at the court. Extraordinary number of unusual applications from the SG, often stay applications seeking to stay injunctions issued by judges, resistance judges in the Northern District of California, nationwide injunctions. And the court seems very often ready to play. And even though in other settings it will blithely say we're a court of review, not first view, on very thin briefing, and in orders that are vastly consequential but have no reasoning, all kinds of things are happening. Am I right that this is distinctive, and should we be troubled by it?
It's certainly distinctive. The numbers are very dramatic. How often the Solicitor General has sought some form of extraordinary relief, either a stay of district court proceedings, or serve before judgment, or vacation of a stay issued by a lower court. The numbers are remarkable, that how often that has happened in this administration as compared to previous administrations of both parties. I think it's kind of an interesting question on the side of whether the Solicitor General can be criticized for doing that when the court has not pushed back. The court has not rebuked the Solicitor General. In fact, Justice Sotomayor maybe a little bit in this most recent thing, but really she was directing what she had to say at her colleagues rather than at the SG. Whether the question be whether the SG has an obligation to protect the court from itself. I think that's kind of an interesting question. But be that as it may, this is an unusual feature. I think it's unfortunate. I think it's a consequence of the polarization. I think, as Adam said, these are important rulings. They're important concretely on the ground, but they also commit the court. I mean, the court will get one of these stay applications and issue a stay on no briefing, just the barest briefing, no argument, without full consideration, without the benefit of lower court opinions. And then it's going to be very difficult for them to rethink. Not impossible, but difficult for them to go back and rethink the position they've taken. So they're sort of snapping into positions. And I think what makes it, unfortunately, kind of easy for them to do that is the way they're a little bit on teams. And, this is something from those judges in the lower courts that we know what they're up to. They're trying to thwart the Trump administration. We're not going to allow it. And that, I think, makes it easier for them to reach judgments without thinking it through. I think it's an unfortunate development. I wish the court I wish the court wouldn't do it. I think the doctrinal avenue to stop doing it is to insist that the government actually show concretely why the injury to it is so severe that it needs extraordinary relief now compared to the possible injury to the people on the other side. But the view seems to be, no, if the government is being prevented from implementing a program that is per se a serious injury, unless the merits are very strongly against it, we're going to grant it its relief. I think that's misanalyzing the question And I just don't, it's a very peculiar way for the court to decide these questions so quickly with so little briefing when the stakes are so high.
Can I say something about that in response? I mean, David and I both worked with Rexley when he was the Solicitor General, and candidly, I suspect that Rex would not have authorized anywhere near as many requests for extraordinary relief, not because he doubted whether he might actually be able to succeed. Just, his view was that we should save that kind of a request for something where it really means the world to the federal government and not burden the court. But he got criticized a lot for not using the full extent of the goodwill and authority that he had and that office had at the time. And ultimately, he walked away perfectly happy at the end of the day. But I think the point you made, which is really the telling one, is the court, if it wanted to discourage it, there's a pretty easy way. It's either say no on occasion or say no with something that expresses at least some agitation with the notion that you're going to keep interfering with the ordinary course in which we operate. Because the truth is, most of us, at least I think, envision that the justices are much happier in a world where you file your cert petition 90 days after, and then opposition, and it gets granted, and it gets heard, and it gets done, and then they get to reflect on it for more or less time, depending on the circumstances, and that they wouldn't be that thrilled with this. But if they're not going to say anything, I can understand why the administration would have a hard time saying, well, why would we stop now?
Can I offer a little bit of a defense of both the administration and the court? I think that I agree with David and I agree with Carter that this is something that the court doesn't like. But I think in many ways this is just the problem with nationwide injunctions, because if you have a district court entering a nationwide injunction against an important executive policy initiative, of course there's going to be tremendous pressure on the executive to challenge that, because if they don't, the policy is going to remain enjoined. And the Supreme Court is going to feel some degree of obligation to step in precisely because it's a nationwide injunction. And these nationwide injunctions essentially thwart the ordinary development of the law. And so, I think that this is a dynamic that you could easily see in a different administration. You saw, just the slightest touches of this in the Obama administration when you had the nationwide injunction issued by Judge Hainan in Texas of the earlier version of either DACA or DAPA, whichever program it was. But now we're seeing this sort of in full flower. And I think it's a problem that is potentially here to stay. And I agree that the Supreme Court is sort of at its worst when it is acting on an expedited basis and when it's acting on limited briefing, and this practice of issuing these orders that really have no explanation is, very much a deviation from the court's ordinary course. But it's totally understandable why this is the dynamic now with these nationwide injunctions becoming more common. And the only other thing I would say is that I think even leaving aside nationwide injunctions, you just see in civil litigation more generally, more of the action now is in the area of interlocutory orders of one variety or another, whether it's preliminary injunctions or appeals on class certification, because in civil litigation, the reality is that very few cases go through trials and final judgments. And so to some extent, even in litigation that doesn't involve the government, you're just seeing a lot more pressure being put on appellate courts and even the Supreme Court to decide issues in a kind of preliminary context.
Can I just say something about that? I mean, the nationwide injunction issue is tricky and hard, and it's not clear that they're, it is a difficult issue. But if the court is unhappy with nationwide injunctions, it should grant the case, raising the question whether nationwide injunctions are okay, and say whether they're okay. And if it's unhappy with the way courts of appeals are dealing with interlocutory orders on class certification or other matters, it should tell them that in a full opinion, rather than doing this sort of one at a time. And I agree nationwide injunctions are part of this. I actually think there's a lot more to be said in defense of them than a lot of people do. But okay, if the court doesn't like them or doesn't like them in certain circumstances, think it through, work it out, tell us about it instead of this kind of piecemeal thing that they're doing.
So the other night in this asylum order, there were two noted dissents, Ginsburg and Sotomayor wrote. And the journalistic problem then is everyone thinks it's 7-2, but maybe it's not 7-2 because maybe people in this kind of setting silently dissented, but just didn't say so. Do you guys have intuitions about whether that's likely or not? Whether we can take at face value what the vote count was?
I think it could happen. I don't know enough about the particular context here to know how likely it was.
And I guess we did see in one of those, also, we had the death applications last year where the question was, does a religious inmate get to bring a faith advisor of his choosing into the death chamber with him? And it turns out that Alito had dissented but didn't choose to say so for some time.
I actually have a speculation about this. I think there are three people up there who really are trying to avoid 5-4s along the usual lines. I think the chief wants to avoid them. I think Justice Breyer wants to avoid them. I think Justice Kagan wants to avoid them. And I think there's some stuff going on with that. And it wouldn't shock me if Justice Kagan and Justice Breyer suppressed their dissent in this case in order to kind of help out the chief. This won't be a 5-4 partisan. And actually, this is just wild speculation. In a previous iteration, not a previous iteration, but a previous case that was a little bit like this one. This one is about applying for asylum in the first country you come to. The previous case was about whether someone who had snuck in could be denied the right to apply for asylum. In that case, the court denied a stay, ruled against the administration by a 5-4 vote with the chief siding with the liberals. And it wouldn't, I mean, I don't know how explicit this is, but it wouldn't shock me terribly if the idea was, okay, we will not make this a 5-4 in exchange for your having avoided the partisan 5-4 in the other case. But I think you're going to see that dynamic, and I think you're going to see suppressed dissents, as we've already seen kind of opinions that are kind of mushy opinions in order to avoid that kind of 5-4 breakdown.
And interestingly, that earlier asylum case you mentioned was also from Judge Tiger. It prompted the Trump criticism that it was issued by an Obama judge, right, which prompted the chief's statement that there are no Obama judges and no Clinton judges and no Bush judges, questionable statement. But it was in light of that that the chief's vote also might have made a bit of sense. So the big surprise of the term, I think we could all agree, was the census case. Any sense of what was going on there? It's after argument, a lot of people reported, including me, that it sure looked like the right side of the court was going to rule for the administration. What do you think happened, Pam?
Well, you get 80% of the way through the opinion and you still think they're going to rule in favor of the administration. It's sort of like, watching a ball in a bowling alley and it's going whoosh at the very end.
That's why most people read the last line first.
Yeah. I think part of what happened in that case is that the Chief Justice decided that if the administration is not going to take seriously the responsibility to adhere to the rules, he's not going to save them under conditions where it's, this goes back to your quotation, your allusion to the fact that the chief clerked for Judge Friendly. There's that line in the last part of the opinion, the quotation from Judge Friendly about, as a judge, you can't be more credulous than the average guy on the street. And the problem here is that by the time, first the administration just did a disgraceful job of trying to come up with a pretext here. If the administration had just said, we're curious about whether or not people are citizens, they would have won this case going away. They would have gotten the 5 votes. But, it's like, for the administration to claim that the reason they had to ask this question was to enforce the Voting Rights Act was so patently ludicrous and so clearly pretextual that when stuff started coming out about that, it was really hard, I think, politically for the court to ignore that because they would have been lambasted, especially after the Hofeller stuff started coming out, And so it was so obvious that what had happened here was the purported justification was not the real justification, that there's also that line, I think it's of Justice Franklin's, we can't ignore as judges what we know as men. And this was what would have happened if the first travel ban had gone up to the Supreme Court, which is when you lie, you get in trouble. It's the cover-up, not the crime that causes the problem here. And I think that was what was going on with the case.
Other thoughts on the census
You
case?
know, it's interesting. I mooted the census case at Georgetown and said it after the council were finished that, you know, it at least it felt to me, if you coming from it fresh, not having a dog in the show, just reading it, that if this had come up in any other context, it wasn't census, it was a more mundane, ordinary administrative law case, it struck me as the kind of case where the DC Circuit routinely says to the agency, seriously, this is the best you got, go do it again. You know, it's just not right. And I thought, you know, why aren't we sort of arguing it in that sense? Why are we being why do we have to raise the rhetoric in it and talk about pretext, et cetera? Just like, you know, this doesn't work. It's not an adequate explanation, and DC Circuit judges have seen these 1,000 times, right? You know, and there are two or three people from the DC Circuit. At least one of them ought to have that same reaction, say, you know what, I've got a deja vu reaction to this. And in some ways, it sort of felt like, even though there may be lots of other motivations for how the chief came out on this, but in some ways, if I were him and I were trying to sleep well at night, if I thought this made much difference, I would say to myself, if I'd been a DC Circuit judge and this had come up in an ordinary context without all of the political hoopla about it, I would have readily set it aside and said, this is a nice try, but this isn't getting it done, do it again. Now, originally, if you do that, the timing runs out and you don't have enough time to actually be able to do it. But that's not an excuse for not to say to the agency, look, this isn't actually good enough for government work, but we don't have enough time for you to be good enough for government work in this case. So we're going to give you an even bigger break. That can't be right.
Yeah, I mean, it's interesting. Obviously, we've talked about Jones, or alluded to Jones reporting on this, suggesting that the Chief Justice changed his mind after the oral argument. There was Jan Crawford's reporting way back when in the Affordable Care Act case, suggesting that the Chief Justice had changed his vote after oral argument. And I think the one thing that these two cases have in common is that there was concerted outside pressure on the court even after the oral argument. Here, in light of the documents that came to light from the dead political consultant's computer. In the Affordable Care Act case, it was this rather odd but seemingly sort of concerted effort through op-eds to really put pressure on the court. And I wonder if this is going to be a new fact of life and really big litigation before the court. You know, it used to be that after the oral argument, people just forgot about the case until it was actually decided. And now you're sort of seeing this post-argument litigation, whether actually in the courts or through the press. It's very striking and very unusual.
Virtual briefing. Allie Larson.
Yeah, looking over at Allie here. So.
You guys are now more important than we are.
This idea of the concerted pressure that an op-ed can impose on the Chief Justice of the United States, you really think that's a thing?
I think it might be a thing.
Good.
I thought you had a wall between your reporting and the op-eds, Adam.
I'm just delighted that the failing New York Times still has some influence.
Sad. But I actually think this is a slightly different case in a way than whatever was going on with the Affordable Care Act, because the reason that this stuff came out was not because people were litigating at the Supreme Court. It was because there was ongoing litigation in the district courts in related cases. And you can't expect people to stop their litigation in the related cases because the Supreme Court is deciding the census case. And so I think it may have had the same effect, but I don't think that it's right to say that what was really going on here was a kind of conspiracy in the civil rights community to take an issue that had been submitted for decision and to try to pressure the court out.
No, I think that's a little bit disingenuous. On the same day that they filed in the district court, they sent a letter to the Supreme Cort. So I don't think they had their eye just on the district court.
No, I mean, I'm not saying that they didn't try to also influence the court. It's just to understand that there was ongoing litigation about redistricting in which this material came out.
Yeah, and I would actually note that, I mean, apropos of what we were discussing earlier, you know, this sort of illustrates, I think, the same limitation on capacity that we were talking about with regard to the shadow docket, because in this case, because the proceedings were, you know, sort of, they weren't quite in an interlocutory posture, but they sort of were, you know, you had ongoing proceedings in the district court. You had this sort of new factual material being presented to the Supreme Court in this very unusual way, and the Supreme Court just does not have the capacity to sort of process that. And similarly, the district judge was like, what do I do with this information? Because the Supreme Court has the case. And so I think it just illustrates the fact that, you know, the Supreme Court, you know, operates at its best when it is operating in the traditional way. And I think it faces challenges just as soon as it sort of gets outside that context.
Well, and I think it's also facing challenges now from the fact that we have an administration that is lawless in a way that was not true of prior administrations, whether Democratic or Republican. And so you have an administration that really, I honestly believe, wants to wreck the census and would be very happy to wreck the census and to have dramatic undercounts in minority communities. And the upshot of that is that, you know, Don Verrilli gave a really interesting lecture at Chautauqua earlier this summer about how does the Supreme Court respond to extraordinary cases. And he talked about the kind of current moment, and then he talked a little bit about what happened in Korematsu, which is, remember what Justice Jackson said there is, as a court, we need to just step out of this because anything we do here plays a role in later cases as well. And so one of the questions is, how does the court respond when you have an administration that has a very different attitude toward, at the top, I'm not talking about the whole administration, but at the top, has an attitude towards law that's just very different from anything that we've had in recent history.
I'm not sure everyone accepts that premise.
That this is a different administration?
On the court. There are some members of the court who are perfectly happy to say, we'll give deference to any administration, they get to set policy.
It'll be very interesting to see whether that's in fact true.
Okay. So you said earlier, Pam, that the court, in fact, was trying to lie low this term, and the reason it took the two big cases it took was because
It had to.
It had no choice.
Yeah.
And one of them because of a supposed deadline, which got softer once the administration lost. In the census case, they said they had to print the forms by June 30th, and then there was a little after-the-fact scramble. This next term, though, seems to be shaping up to be a much bigger term. We heard the case argued just now, enormously consequential cases. DACA, enormously consequential, very likely an abortion case. The court scheduled today for argument a case that may or may not be moot about the Second Amendment. Was that a holding pattern, you think, for a year, and now they're coming back? And do they care that all these decisions are going to come in June of 2020 in the midst of a presidential election?
Well, I mean, I had heard kind of through the grapevine that Justice Kavanaugh had said that last term they tried to avoid taking a couple of high-profile cases. And certainly, you know, the Title VII cases were teed up in the long conference last summer. And so they were ready for the court to decide, did it want to take the cases or not in September, and they didn't take them till April.
It appears the fourth vote was late in coming.
Yeah. So, you know, it took them a long time to decide whether they wanted to take that issue or not. You know, the problem is if you try to put off taking controversial cases, at some point you're gonna end up with a lot of them.
Do you guys think the presidential election figures in the court's thinking at all about when to hear cases?
I mean, they're human. I mean, I think it makes some, you know, look, the court still uses primarily the same criteria in every case. They're looking for square and acknowledged conflicts in the circuits. That's certainly true in the Title VII cases that they had to, man, if you're ducking clear and acknowledged conflicts in the circuit and issues that arise on an almost daily basis, then you've abdicated your responsibility as a court. So, to some extent, all things considered, would they prefer not to decide really hard and controversial cases? Probably up to a point. I mean, there must be some limit to how many patent and ERISA cases the court really wants to hear in a particular term. I don't understand that. I mean,
But they've got COGSA if they need to fill the docket.
exactly.
That limit has not been noticeable in recent years, I mean, to be fair. I mean, I think there are relatively few cases of the ones you've mentioned, with the possible exception of the Second Amendment case, Adam, where you could say the granting of review was really elective. I mean, I think most of these cases are cases that, I agree with Carter, that the court truly had to take. And when you have a case in that category, I think the fact that it's an election year or not really doesn't play into the calculus. After all, that's true 1 out of every 4 terms.
But, if you come back with a question of, should the court overrule X, and X happens to be one that you think might make a huge difference in terms of how the public perceives the court, would you do that in an election? I don't know. I mean, I can imagine you might have a hard time picking up the 4th vote to go down that path in a particular circumstance. But as I say, that's because they're human. And, look, they get paid the same either way, whether they decide hard cases or easy cases or whatever they do. So, that's the beauty of the way this sets out. For the most part, except for the redistricting cases,
Well, and
they can pick their own docket.
Yeah, and their salary per case decided has gone up dramatically.
Another dynamic that might be operating here, of course, it only takes 4 to grant. And if 4 want a grant, they have to think about, is the 5th going to come along? And I could see, in the Louisiana abortion case will be an interesting example of this. What are they going to do with that case? Because to do something that looks like, I mean, they can't be insensitive to the effect it will have on the election if the headline is certainly court overrules Roe against Wade, or even court overrules Whole Woman's Health against Hellerstedt. They can't be insensitive to the effect that'll have on the election. So I think there's maybe kind of a dance going on about whether, and again, I think it's the chief who's the key here, whether the other 4 want to kind of jam the chief and put him on the spot where, is he going to vote against his team?
Are you sure that's the right analysis there? Because if they, having stayed the 11th Circuit, having stayed the 11th Circuit, if they lift the stay.
Oh, the Fifth Circuit.
Fifth Circuit? Yeah. Fifth Circuit? That answers the question. Don't they almost have to take it?
Yeah, I suppose since they stayed it, I mean, I suppose they could. Yeah. I mean, what would they do now? If they lifted the stay, the Louisiana law would go into effect.
Effectively deciding the case.
Yeah.
So more broadly, where do you see the court's abortion jurisprudence going? I mean, this case it may well overrule Hellerstedt. It could distinguish Hellerstedt on factual grounds that the facts on the ground are different in the 2 states. So it's likely an application of Casey, not an assault on Roe. But where do you see the progress of the court's abortion jurisprudence going?
Well, I think that's really tough. If I were sort of in the middle of the court, I would be tempted in that case to say to the 5th Circuit, look, this statute is the same as the Texas statute that we decided in Hellerstedt. Hellerstedt's 3 years old. Maybe Hellerstedt should be overruled, but we're the ones who are going to make that decision, not you, and summarily reverse. I'd be tempted to do that. And here's why I'd be tempted to do that. I think, however conservative the Supreme Court is, there are lower court judges who are going to be more conservative and who are going to think the Supreme Court is moving too slowly. And I think they're in a position to put the court in the same kind of position. Are you going to, we're going to do something that really amounts to overruling one of your decisions. Of course, we won't say that, but we'll do something that, finds some very fine distinction between something you've decided and in effect do something inconsistent with your previous decision. Okay, now what are you going to do? Are you really going to reaffirm this previous decision that we know you don't like? Or are you going to grant the case and overrule this case? And if I were on the court, I would say, I don't want you guys putting us in that position. If you're unhappy with something we did, here's the opinion you write. You say, oh, we don't like this precedent of the Supreme Court, but we're bound by it. So we're going to decide inconsistent with that. We hope the court will take another look at this case a month. that's the way you do it. And I would try to teach the Fifth Circuit a lesson that, that don't put us in that box. But I don't know that they'll do that, but I can see a reason to do that.
I think the way that that might happen is if the chief has really made up his mind already. And of course, it's hard to know what to read into that earlier stay ruling. But if the chief has basically decided, for whatever reason, that this is essentially, whole women's health 2.0, I could see him wanting to decide this case in as sort of summary a fashion as possible.
Yeah, I mean, we got a little bit of a hint of this from the opinions respecting the denial of certiorari in the Indiana sex selection abortion case last term, which is, remember, there were two pieces of the Indiana law that were up in front of the court. One was about the disposal of fetal remains, and the other was about a prohibition on abortions that were designed to select the sex or race, that were based on the sex, race, or disability of the fetus. On the first one, the court reversed and said, well, the rationality review is what applies here, and it's not an irrational statute. And on the second, the court said, well, we're denying certiorari here because we don't take cases, in parentheses, like this, unless there's a conflict in the circuits. And so I think what they're hoping is that the federal district courts and federal courts of appeals will continue to apply the precedents as written, and then they don't have to take the issue unless and until they're ready. By contrast, if what you have is things like the fetal heartbeat laws, if one of those gets upheld by one of the courts of appeals, there's no way to square that law with Roe against Wade. And there will be a conflict in the circuits, and there'll be the question of whether a federal court of appeals has kind of underruled the Supreme Court. And that's something that they may find it very difficult not to take. Whereas I assume that if the federal courts of appeals strike down the fetal heartbeat laws across the board, the Supreme Court's not going to grant certiorari on that.
So we have about 10 minutes left. I have a suspicion that there are questions from the audience.
Or you could just cold call on people.
Yes, Beth.
The discussions about the court deciding these injunction cases on such a short record and all of that. Haven't you seen, though, that even in the courts of appeals, it seems that injunction cases just across the board aren't treated as injunctions anymore. They're treated as merits. I mean, you can read Court of Appeals opinions where you think, oh, it's likelihood of success. It's said once and then it just disappears. So that to me seems to be, and I think now it's going to encourage it even more. So do you think that maybe is just part of it because we've moved away from injunctions really being litigated as something that is temporary before the merits? They do seem to merge in a lot of cases.
Well, that would suggest that it's actually the advocates who screwed this thing up, all right? I mean, so I'm pushing back against that suggestion, but no, I mean, there is something to that. I mean, and it goes to Cannon's point that we sort of press the litigation sooner because we know to the extent it continues to drag out, we're never going to get to a final resolution of it. And if you can get the court to act on it more rapidly, although I have to say, I have mixed feelings about these things. I have a lot of cases where I think to myself, most people's knee-jerk reaction may not be positive to this. So maybe it's, let's just take our time and educate the court and hopefully get there in due course. But, obviously on hot-button issues, it's more important to get a decision quickly than it necessarily is to educate. And so, yeah, it probably is partly our responsibility.
I also think there's some lower courts that have pretty good processes in place, and Beth, you'll have some familiarity with this from your time at the Justice Department. The Ninth Circuit has a separate track for preliminary injunction appeals that in my experience actually works pretty well, that moves them along pretty quickly, and that does have, but other courts don't. I agree. So it's, I think it's something that the lower courts
may have to adopt that.
Yeah.
Bob?
I want to go back, if you could, just a second to Robertson, the Commerce Department case. And some of us thought after that ruling that it wasn't over, that he had given the administration a way to do what it wanted. Some of us was called back from vacation because we thought the administration was about to do that. And then nothing happened. Did Roberts, in your opinion, know that he was killing this thing, or was he leaving the administration a way to get what it wanted?
Did John Roberts screw up Bob Barnes's vacation for no good reason?
The answer is no. The answer to your question, I think he expected that this was going to kill the question on the census. But you know, the role you play, and candidly, you see this in a lot of DC Circuit opinions, is look, I'm not telling you you can't get to where you want to get. I'm telling you, when you explain it this way, you're not getting there. Now, if you got a better explanation, bring it back, and I'll be happy to take a look at it. Just turned out they were going to run out of time. And even if the secretary had come back in and said, "Oh, my bad, I don't care. Did I say Voting Rights Act? No. I mean, I'm just curious about this information." You know, that would have been a tough one to sell up through the court system again quickly enough in order to allow it to go into place. So I think the chief genuinely meant, look, this is how a judicial review of administrative agency decision-making works. You come in with a bad explanation. If I reject it as arbitrary, capricious, or otherwise inappropriate, you get another shot at it. And you know, if you run out of time, that's on you, not me.
Jesse?
No, that's good.
This is more of a journalism question than a legal one, but
You can answer it.
I speak for the editorial side, but I can. And I was struck by Ken's comment that this sort of op-ed campaign was odd. And I'm just wondering, I wanted to hear you say more about that. My initial reaction was, what do you expect us to do?
I think the thing that was unusual in the Affordable Care Act was that you had this sort of burst of activity that took place sometime after the oral argument. You know, usually, in my observation, what takes place is you have the oral argument, people write things for a day or two, and then the case sort of falls off the radar screen. And at least if you believe Jan Crawford's reporting, there's some suggestion that that might have been because word was getting around that maybe the Chief Justice, in fact, had doubts. And, you know, if so, that was concerning at the time, and I think remains concerning, both because it suggests that the court was in fact leaking, but also because it suggests that may have actually had an effect. You know, and I do think that is pretty unusual, at least historically.
Yeah, I will tell you that if you asked me 5 years ago, and a client said, "Look, you know, what value will it be to go and get a New York Times or a Wall Street Journal or any other editorial in support of the merits of the outcome of the case?" I would say zero. You know, I mean, spend your money on your really good lawyer and don't waste the time. You may wonder why I come to that conclusion. But anyway, whereas today I might have a slightly different take on that question, which suggests that you can't. That's another button, at least in your arsenal, you got to think about.
But editorials have existed since, you know, hundreds of years. There's nothing new about that. What is new is what Jeff and Allie have written about, the so-called virtual briefing, which is a little more sophisticated than most newspaper editorials, not Jesse's newspaper editorials, but other newspaper editorials. A justice once said to me, you guys write these editorials, do you think we've overlooked something? But the virtual briefing that Jeff and Allie write about take place. They kind of read like briefs. You know, it's on the Volk conspiracy or Balkanization or some other blog, and it's by Marty Lederman, and it's, you know, longer than, you know, it would burst the page limits at the Supreme Court, these blog posts. That is new. Anything wrong with it?
Siri may have an opinion on that.
As a First Amendment man.
Interesting question.
Thank you, Siri. Wait a second, is she going to comment on our answers too?
Go right in and say, why do you ask?
I mean, I think it's concerning because I would think it's concerning because, like Carter, I practice before the court in the traditional manner, which is to say through briefs and a developed factual record and through oral argument. But the reality of life in 2019 is that we all have information coming at us from every direction. I think that the research that Jeff and Allie and others have done, you know, demonstrates something that I think all of us long suspected, but perhaps didn't know for certain, which is that judges and law clerks and others are reading all of that. And it is inevitably going to be influential if all of that is being read.
Which frankly, is just a really good argument for going back to 160 cases a term, because then they wouldn't have any time to read all that garbage.
Well, particularly if we couple this with the justices being paid per case, this could be a great thing for the private Supreme Court bar. But I think it is concerning precisely because it is the Wild West, and if information is coming in and it hasn't been verified through the litigation process, particularly factual information, I do think that's somewhat concerning.
And that's been a problem with amicus briefs at the Supreme Court for generations. I mean, people come in with facts that are not tested by anybody, and where the parties don't even really get an opportunity to respond to them. And so it's not just the virtual briefing, it's the actual briefing by non-parties that causes some of this problem.
Yeah, so on the one hand, justices have always read a lot of stuff, and they've read law review articles and so on. But I think what's happening here is this is stuff coming out post-argument to which you don't get to reply.
Or, I mean, to take amicus briefs, I mean, sure, and Allie's written about this too. This is an advertisement for all of Allie's work. But the advantage with amicus briefs is if you're the oral advocate, at least you know what's in those amicus briefs and you know that there's a possibility that that's going to influence the court. Now you have no idea what the justices or judges on lower courts are reading and what information they might be getting. And something that I've started doing before oral arguments in the court is literally Googling my own cases and just seeing what is out there, just in case there's something out there that a law clerk or a justice might have read. And certainly that's something I wouldn't have done 5 years ago.
I mean, I mean, amicus briefs, of course, been around for a long time, but they really have exploded. And the Supreme Court litigation has increasingly taken on the sort of feel of a political campaign. I mean, you mobilize your side and you just flood them with amicus briefs and you get op-eds and you get blog posts. And of course, at post-argument, it seems a little more troubling. I think pre-argument, when it makes positions there's an arms race to make your position look good, or make your position, that might have been sort of marginal, make it look legitimate. And you get person after person after person endorsing it. I'm not sure what to do about it. I think it's an artifact of polarization. It's an artifact of these very organized sort of legal teams. It's a Federal Society on one side and ACS on the other, and they're both trying to do this sort of thing, and various other interest groups are playing. And you have the feeling that the legal system works better when it's a kind of I mean, maybe this is old-fashioned or elitist or something, but a relatively confined universe of arguments that are acceptable, and kind of there's a good sense of what they are and what they aren't. And we've lost that. I don't know if there's any way back to it, but I don't think it's a good development.
Yes, one last question.
It's more a comment, but from an amicus perspective, the part of the case on special districts, and John Oliver had done a pitch on special districts. We responded to it in our amicus brief without referencing it, knowing that some clerk was going to look at this and laugh and say, special districts are the bane of America's existence. And it's real. So that's my, sorry for too many comments.
Okay, Eric.
Sort of relatedly to all this, is one bit of collateral damage going to be a weakening of the institutional position of the Solicitor General as neutral, stable advocate for the interests of the United States over the long term in an environment where, the Solicitor General is more and more just some other advocate than.
Yeah, I mean, I'll give you my take on that. I think the answer is no. I mean, obviously, there are going to be some instances where some people are going to react negatively to some positions taken. But if you look across the breadth of the Solicitor General's docket, I mean, the reality of the Justice Department, there are essentially three principles at work here. You have money, government wants it. Government has money, you can't have it. Otherwise, you go to prison. And those principles dictate the right outcome in about 95% of the cases, and the SG presents those principles as effectively as any institution in the United States, and accordingly will continue to receive respect for the positions that he or she takes in that regard. And the fact that there are a handful of cases in which they sort of spin in ways that get a lot more attention than what they do day to day will have some effects, but to me at least much much more limited.
So I think the Solicitor General's office is getting less deference from the court, but perhaps not for the reason that you were suggesting. I think it has very little to do with the positions that the SG is taking in, the few high-profile cases, and more to do with the fact that the court has become, across administrations, more skeptical of, the government's theories of criminal prosecution, of course, less deferential to the administrative state. And so I think just across the board, there's just a little bit more, and frankly, I think also less trusting of factual representations being made by the government, in light of the fact that there have been some pretty high-profile instances where those factual representations may not have proven to be completely accurate. And so I think really for a variety of reasons, I think you are seeing a slight decline, but I think that, again, that's administration over administration. That's not specific to any one administration.
I mean, back in the day when Carter and I were in the Solicitor General's office, I mean, if you had a criminal case before the Berger court, I mean, you had to work pretty hard to lose that case.
I was there for that, though. I could get that. I could get that done. Yeah, exactly. That's what Fry gave me those.
I do think it's actually, I mean, people, Adam and others have talked about a sort of greater degree of agreement on the court. I think part of what has happened is the left and the right have converged. This is consistent with what Cannon just said, converged a bit on distrust of the government, where the liberals aren't as distrustful as they used to be. Used to have Justice Brennan and Justice Marshall, who were very hostile to the government position in criminal cases, and now the liberals less so. And conservatives are more distrustful of the government position in criminal cases. There's a libertarian strand there. I mean, not in every case, and maybe not enough, depending on your views. But I do think there is a kind of a distrust of government not quite across the board, but much more so than there used to be on the court, and that's filtered into the reaction of the SG.
All right, we're over time. Please join me in thanking this fantastic panel.
Is there a meeting here? What happened? Did you just? You just had a
I think the documents pushed them
after hours, and everybody should have gone home on a Friday. So there shouldn't be any emails because it's after hours.
After you realize that everything the government said in the district court was a lie.
The real reason, which is not, I'm curious, but I want to gather data so we can do one person, one vote differently. That would have flown just fine too.
Right, of course. If they had given their real reason, it would have been upheld.
I mean, it doesn't help that Wilbur Ross is a moron.
Right.
Yeah.
I mean, some of them wanted to suppress Hispanic votes, so
right.
I mean, that
But
was
I
part
know,
of the real reason.
but if
That's just an incidental
if
benefit.
they had just said we want to allow states to draw districts based on citizenship, I don't think the court would have. I think the chief would have gotten along with it.
Yeah, I think so.
In a trial setting,
And also, I mean,
you can't just come up here and say something so ludicrously false.
it was also a happy coincidence for him that he can give something to each side, and to your point, that he has some institutional authority.
All the press is right
But it looked last minute, suggesting not just that it was obvious.
Ellie Larson show.
That doesn't just look last minute. It was
you look to me like you took it in stride.
You already know my views on this subject, so. Yeah, no, it really bothers me. I mean, with this computer, I will type the name of my case in the way, and
That's an interesting notion.
crazy and new.
I always hated amicus on the merits. I wish everybody would go home except for the SG.
I agree, because it's just it feels like a congressional hearing. It's like people are submitting position.
There was a time years ago when quality of one lawyers was so bad.
Well, right. That's long gone, issue.
Right.
And the reality is that it's very rare.